Good evening. Welcome to the Jersey City Zoning Board of Adjustment. This is our regularly scheduled meeting for February 23rd, 2023. Okay, let's get started with the Pledge of Allegiance. I pledge allegiance to the flag
To the flag
of the United
States of America
and
and
to the republic
for which it stands,
one
one
nation,
nation,
under God,
under God,
indivisible,
indivisible,
liberty and
with
justice for all.
and justice for all.
Okay. Any sunshine announcements?
Yes, in accordance with the Open Publics Meeting Act, notice has been given to the Jersey Journal, the Jersey City Reporter, El Especialito, and posted with the city clerk on Friday, February 17th, 2023. We have the notices to be marked.
Okay, this will be A1 for tonight's agenda in evidence.
Thank you. Okay, can you please take roll call when you're ready?
Yes. Commissioner Green,
Here.
Commissioner Park,
Here.
Commissioner Donnelly,
Here,
Commissioner Arujo,
here,
and Chairman Jacobs.
Here.
We have a total of 5 commissioners tonight.
Thank you. Can you please swear in staff when you're ready?
Raise your right hands to be sworn. Do you swear or affirm the testimony or comments you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Bridget, excuse me, you should swear in Miriam also.
Oh, I'm sorry. Okay, Miriam, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
And your name is spelled correctly in your box, Miriam?
Correct.
Okay, thank you.
Thank you. Before we start, Francisco, I got a missed call from Ahmed. Do you have his number? Do you want?
Do not.
I tried calling him back, and it went straight to voicemail. But maybe someone should like text him or see what's going on. Hopefully he's okay.
I know he was trying to get access to the link or to the Zoom. So I sent it to him one more time and then I'm gonna email him while we continue.
Okay. I mean, I don't know that I want to give you his phone number now just by telling you his phone number.
No.
Okay. I'll text you his phone number. Or email it to you. Okay. Any correspondence?
Let me share my screen so everyone can see. Okay. In terms of adjournments, those that are here remain adjourned. I do want to make sure that item A, case Z22-057, the address is 8183 Hutton. They have carried to March 9th, 2023 with the regular meeting with preservation of notice. So those that are joining for this item, please know that they will hopefully be going before the board on March 9th. Other than that, with withdrawals, item B, case Z22-052, the address is 85 Monitor Street. They have also requested to carry to the March 9th regular meeting. And other than that, all items will be moving forward tonight.
okay.
Okay. Great. Thank you. So with that, we'll proceed with new business. And we'll start with case Z22-108, 35 Orchard Street.
Promoting Thomas Lane. Oh, promoting Chuck Harrington.
Good evening. I'm filling in for Tom on this one. So it's Charles Harrington of Connell Foley on behalf of the applicant. This is a request for an extension of the approval. We did provide public notices, so I'd ask that those be reviewed and marked into evidence.
Yes, Chuck, we did review them. Bridget will give them to you and you can mark them as A1. It's your affidavit and proof of service and notice of publication. Thank you, Chuck.
Okay,
Okay, so this will be A1 for this application.
Mhm.
Okay.
so just briefly, the application that is the subject of this request was approved by this board initially in February of 2018. And then we came back and had an amended site plan approved in early December of 2018. We subsequently came back after the COVID emergency protections and requested a 2-year extension through December of 2022. The property, so nothing happened within the the COVID pandemic, except for the client the prior client sold the property to a new developer. So they are seeking an additional 1-year extension to move forward with this project. They're working on their documentation now. This would be the last year that they can request this extension, and we're asking for an extension to December 4th, 2023. So it's really in the next few months they have to move on this and on the proposed project, which the proposed project, if some members may recall, I don't know if Commissioner Donnelly and Chairman Jacobs were on the board at that time, I believe, it's a 9-story project, which actually the 9th story is a little penthouse level with on the corner of Orchard and Monticello, and it is has 35 residential units, 5 of which are affordable, with 3 being workforce units and 2 moderate income units. So we think it's a good project for the area, and it brings the affordable components as well. And the new owner is looking forward to moving on this as soon as possible.
Okay. I don't know, does anyone from the board have any questions? Or, I mean, Chuck, is there anything else? I didn't want to cut you off, so I think that concludes your statements about this extension request, right?
Yes, it's all about the COVID and the pandemic. Nothing happened there, and then there's a new owner, so he wants to move forward. Okay.
I mean, does anyone have any questions? I don't know. We're in a position where I want a project like this, and disappointed it hasn't happened yet. I mean, I find it hard to believe that there couldn't be demand for moving forward with this type of project with this level of density, with an affordability component in McGinley Square. Does anyone have anything else to add, or does anyone want to make a motion?
Mr. Chairman, I'd like to make a motion that we
You want
approve.
to ask the public if they want to comment?
Sure. Is there anyone from the public that has any questions or comments regarding this extension request for an already approved application on 35 Orchard Street?
At this time, I see no hands raised.
Okay, thank you. So we'll close the public.
Motion in order?
I don't think staff has
Mr.
anything
Chairman?
to say, correct?
The only comment I have is just to continue the conditions that were applied to the previous application. That's the only.
Right.
Right, and those would be acceptable.
Great. Kim, do you want to make a
Yes.
motion?
Yes, Mr. Chairman, I'd like to approve the extension for the case Z22-108 at 35 Orchard Street with any conditions.
I second that.
Commissioner Green,
Yes.
Commissioner Park,
Yes.
Commissioner Donnelly,
Yes, and in the words of former Commissioner McCormick, please just get this done. No more extensions. We're done.
Commissioner Arujo,
Yes.
and Chairman Jacobs.
Yes.
Motion carries, all in favor.
Aye.
Okay, thank you very much.
Thank you. Okay, so we'll proceed with case Z 23-001. The address is 1811 John F. Kennedy Boulevard.
Promoting Michael Higgins.
Okay.
Good evening, members of the board. Michael Higgins of Castano Quigley and Charami on behalf of Hassan Chaudhry, the applicant. This is for 1811 John F. Kennedy Boulevard. It's block 25501, lot 15. This is not a notice application as an extension. So client originally obtained preliminary and final site plan approval here with C and D variances on July 11th, 2019. This was memorialized August 15th, 2019 by resolution. And those approvals expired on August 15th, 2021. I'd like to actually correct a small clerical error in the letter that stated it's a 1-year extension. We're actually requesting a 2-year extension. If I can just amend that on the record, which would carry us until August 15th, 2023, if granted. The basis for the request is that the approvals were obtained by the previous owner before my client purchased the property. And in this time period, the building code changed. So we've had to, the architects had to ensure compliance of the construction drawings with changes to the building code. So that summarizes it. Happy to answer any questions, like always.
Well, nice to meet you, Mr. Higgins. When did your client purchase the property?
It was in, I believe, the date I have is March 18th, 2021.
And when did this approval expire?
It would be on August 15th, 2021.
Okay, so before they purchased it before it expired, and it's been about 22 months since it expired, since they purchased it, and about a year and a half since it expired. Any reason why you didn't come to us sooner? I mean, we're going to approve this extension most likely, but like this seems like a pretty significant oversight.
And
Yeah,
Mr. Chair, another kind of question that I have is that the reason the council gave for the delay was because they had to make architectural changes to comply with the code, which means that what we approved has changed, right?
Yeah.
So it seems to me if they're changing the plans, they're changing.
Yeah, they need to resubmit new plans, because whatever you did previously, unless you're going to explain to us how it's like a non-issue for us, just a building code issue, I'm not sure I understand.
Yeah, I can't testify towards the exact changes to the drawings. I don't have the architect present here, but the extension would be to continue. The construction would be complying with the previous zoning. We're just trying to ensure that construction drawings are in compliance. There were no changes thus far that I know of.
Okay. Francisco, do you have knowledge of what's going on here? Is there going to be some substantive change?
So I do not. I was not the original planner who reviewed the project. I just got the extension.
Okay. What do you guys, what do people want to do? Kate?
My view is that he needs to come back for this extension when he can answer these questions. Because because if the plans changed, then they need to submit a new application. And if it's just some small thing, then council or the architect needs to be able to explain that. But
If
but there's not enough information on the record for us to make a decision.
If I misspoke, there's no changes to the plans that are proposed. There were changes to the building code that, so after
You
the.
said that the architect had to make adjustments to comply with the building code, which would mean that the architectural plans submitted that we ruled on initially aren't the same.
If I stated that, I misspoke. It's that the architect attempting to ensure compliance with the changes in building code with the construction drawings that were prepared at that time.
So there were no, okay.
Yeah.
I'm even more confused.
So, Mr. Higgins, I think like this is just a easy situation where it sounds like if we can just clear up what's going on here, I think we probably feel more confident about whether or not we need to put forward a new application or just vote on an extension. Would you be amenable to adjourning until the next meeting? Unless, I mean, Vinny, do you think we're overcomplicating this?
I don't see how whatever building code requirements change, I don't see how that would change what we approved. However, I understand what Kate is saying, so perhaps if we just postpone it and either Mike, you could talk to your architect if he can't be present the next meeting and just say, listen, this is what I found out. This is the change. There's a new, exit sign requirement on something. I don't, it could be anything. Kate is correct. Could be anything. I don't know what it is.
Okay.
Yeah, or could we, because I hate to hold this up. We have enough on the
Agenda.
docket. Could we make this a conditional approval based on our assumption that there's nothing substantive?
Right.
Uh,
I think that
you
might
know.
be the better way to go.
I'd agree to that.
Otherwise, I think
Okay,
whatever's going to be submitted for our approval later on, it's not going to be a problem, I don't think, right, Mike? You're not gonna
No,
do
I
that.
don't think so.
right. Yeah,
I think
sorry to tie this up.
that's okay.
Okay, so why don't we first see, Francisco, are there any comments or questions from the public regarding this extension request on 1811 John F. Kennedy Boulevard?
So at this moment, I don't see any hands raised. But if anyone does have a comment, you can press the hand raise button, but none have been raised so far.
Okay, great. So we'll close the public. I don't know if anyone else from the board has any thoughts, but I hope not. Other than let's do what we've proposed, conditional approval. If they're gonna do a whole reworking, which sometimes applicants do and hide it as an extension, then Mr. Higgins will return and he will put forward a new application.
Okay, so I can take a crack at this motion since I'm the one who's making it complicated. Motion to approve the extension for case Z23-001, applicant Hassan Chaudhry. Motion to approve the extension contingent on the architectural changes to comply with code are not substantive in the view of city planning staff.
Okay.
What she said. Second,
Okay. Commissioner Green,
yes.
Commissioner Park,
Yes.
Commissioner Donnelly,
Yes.
Commissioner Arujo,
Yes.
and Chairman Jacobs.
Yes,
Motion carries, all in favor.
Thank you.
Thank you. Have a good evening.
thank you. Okay, so now we're proceeding with case 13, case Z21 099. The address is 28 Mina Drive.
Promoting Michael Solomon.
And I'll swear him in.
Before he appears, let's put on the record that he did notice for this case. So we have his notices, his affidavit, his proof of service, proof of publication. So Bridget will mark this as A1 for this application.
Okay.
I'm here.
Anyone in evidence for tonight? Mr. Solomon, can you put your video on or no?
It is on, miss. I hear you.
No, we need to see you.
Oh, I'm very
Go on.
sorry.
Yeah.
Okay, Mr. Solomon, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Could you state and spell your full name for the record?
Michael, Michael, Solomon, Solomon.
Thank you.
Thank you.
Great, so I mean, how do we get this started?
Well, the violation seems to be a simple thing to rule on. So Marianne, can you tell us what that is? It's a 5 foot 8 inch fence. and our
Correct.
ordinance says 4 feet. Is that the idea?
Yes, they have a violation on file for erecting a fence that is not according to fence regulation within chapter 345, and it exceeds 4 feet in height.
Anything else, or is that
That is
That's
the
the whole-
only, that is
Okay.
the
this seems
violation.
pretty fact-based. So, Vinny, I mean, I don't know, do we even need to hear from Mr. Solomon? Like,
Yeah.
there's like, it's up to a certain height.
Yeah.
It's above that height.
Unless
What-
Mr.
what
Solomon
could you say
used
to
a
argue
different-
against that?
different, ruler. Mr. Solomon? what
Do you
is-
hear from
Yes,
Mr.
sir.
Solomon?
Yes, ma'am. The reason is for this application is to legalize it to be 5'8". The whole house, it doesn't have a backyard. It's just a front. So with the 4 foot fence, we have no privacy or protection at all. We feel like we're being watched all the time. We have had many trespassers. I have videos on cameras. My wife would wake up in the middle of the night. Oh, we're being watched. We had people while she's doing dishes in the kitchen. We see people passing from the side. I'm not trying to make the house look nice or add value to the house or anything. It's just about security and privacy for my family. Well, I'm also not saying that the higher fence is gonna make the house theft proof or anything, but we feel a lot more safer and secure this way. I had an anxiety when we had all these trespassers, and I have a prescription from my doctor, and that I have an anxiety and prescriptions for that. Yes, the higher fence gave us a lot more privacy and security for the house, and I'm asking you if you can legalize it to be 5'8". It's actually 5'7" instead of 4 feet. The front fence.
Are we in any position to make policy decisions about changing the rules citywide about what constitutes a legal fence? I'm assuming no. I don't know, Mariam, Tanya, Vinny, if anyone has any views, assuming our role here is just to, you know what the rules are and apply the rules as they exist today.
I let Tanya speak about this, but I believe this would be a process for a variance.
Correct, yeah. The application is for an appeal with a variance and the alternative. Again, like I think you were saying earlier, Chairman, that appeal is kind of black and white. I think so. Mr. Solomon is making his case for a relief from the standard.
So to put it simply, Mr. Chairman, as far as his appeal of the zoning officer, I mean, his appeal should be denied because it's clearly a violation. So, but then the second part of it is Mr. Solomon is making a case for a variance, which is the way to do this. And so it's up to staff or I guess really staff. Is there some sort of policy decision that we wouldn't approve this? We wouldn't approve this as a variance? It seems like he's got a good point.
Yeah. What do we do, Tanya? Tanya? Marion?
I mean, we have no real problem with this, do we? If it's in the back and he's,
In the
It's in the front.
You know, I was looking at the property on maps or, you know, the picture, and your property goes all around, right? It has a corner property and it goes all
Yes, ma'am.
around. Yeah, I saw that. I personally didn't see, you know, the height, and it has a fence. It doesn't look like it's overpowering the whole corner, but I can see where if you have that corner property, you may want a little more privacy because it does make a big round corner. I would approve the variance. I just don't, you know, I saw it and I think it's okay.
Okay, so the
My
way
2
we
cents.
would vote on this is we would be denying the appeal and then looking at this in the alternative as a seeking of a variance. And then we would be voting on whether or not to approve or deny the variance, right?
Okay.
So can I just get a little factual clarification on something? I'm assuming then that Mr. Solomon built this wall after he purchased the property, correct?
Yes, ma'am.
Okay. I mean, personally, I think you deal with this kind of issue with curtains. I don't know.
Mr. Solomon, I have a question. Were you aware of the height requirements of the fence prior to your putting up the fence?
No, ma'am. Because I would have applied for the variance before I install it. I replaced the 4 feet one with the 5'7" one. I didn't know it's a violation.
Did you look into what the requirements were?
I was 4 feet originally. I just made it 5'7". Then after I received the violation, I knew that since it's a front yard, it has to be 4 feet only, not the 5'7".
And Mr. Solomon, why did you replace the fence? Was it falling apart? What were your reasons for?
No, ma'am. It was only for the sense of security and privacy for my family, especially after we had our daughter last year. It was a nightmare for me. I had people all over the house. I have videos multiple times. People come in, they check the parked cars, they look through the window, and before they knocked on the door. They wanted to make sure if it's someone in the house, can we steal it? I have videos here and cameras for that. Again, I'm saying that the higher fence is not going to make the house theft proof, but it really gave us that extra sense of security and privacy, especially for me and my wife, after we had our daughter last year.
Yeah, I mean, I think different people may feel differently. I think there's obvious reasons why you could have a rule like this or not a rule like this. I mean, yeah, I mean, I personally don't like having fences. So, I mean, I'm not gonna vote in favor of this variance, but I certainly can see lots of people voting for it.
All right.
Should we ask for the public, see if there's any?
Sure.
public?
Anyone from the public have any questions or comments regarding this appeal from the zoning officer on 28 Mina?
So I do see two hands raised. I'm going to promote Raquel Chawanek.
Hi, would you raise your right hand to be sworn?
Yes,
Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
yes, I do.
And could you state and spell your full name for the record?
Yes, my name is Walter Chawanek. My first name is spelled Walter. My last name is spelled Chowanec.
Thank you.
Welcome.
Go ahead, Mr. Chawanek. What do you want to tell us?
Basically, I just want to say that I live next door to Michael, and we've lived there, my wife and I, so she is also here. We've lived there for over 20 years. Prior to the Solomons moving in, the property was dilapidated, and you know, since they moved in, they fixed it up very well. And I am definitely in favor of the fence. Like I said, I live right next door. It is not an eyesore. It does not impede traffic in any way. It doesn't hinder people from seeing the stop signs or anything like that. And it does afford the Solomons the privacy they need, because we do live in a nice, quiet area, but it also, because of that, it does attract a certain element walking around, walking through the property, and you know, looking into their windows. And since the addition of their daughter, I think approving a variance would protect them, but it also protects the neighbors as well, because if the Solomons want to have a barbecue or something in front of their house, because it is their front yard, they don't have a backyard, it gives them privacy, but also gives the neighbors privacy from seeing what they're doing, you know. So I just wanted to, on my behalf and my wife's behalf, to let the board know and to thank the board for their time also. Should have said that first. The Solomons are good people. They work hard. They're a great addition to the neighborhood. And I think the fence would really help them out and also help us out on the other side. So thank you for your time.
Thank you.
Thank you.
We do have one more hand raised. I'm promoting Mina. And if anybody else has any comments, please raise your hand now.
Hello?
Yes,
Well-
we can't see you. Can you turn on your video?
Yes, I'm trying. Sorry.
There you go. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. If you can state and spell your full name for the record.
Sure. My name is Mina, M-I-N-A. Last name Galab, G-A-L-A-B.
Spell the last name again.
G-A-L, like Larry, A-B, boy.
Thank you.
I want to add something there, and I'm sorry, I'm not trying to get my neighbors in trouble, but I'm sorry, this is very customary in the area. I see all the front fences in that area, which I used to live in, by the way, a year ago. All those properties that do not have a back yard, they have their front yard with a fence that's over 6 feet. And I never seen that as a violation. I never thought it was a violation. And I was there when Michael built it, and I was one of the neighbors when he built it, and I recently moved to Society Hall. Now, I go around the property and around the area very often, and I see other properties in the area. And I remember when he built that fence, actually, it was almost in the same level like other neighbors had it. And that's why he built it this way. And again, I'm not trying to get anyone else in trouble, hopefully not, but this is the point, why he built it at that height. In addition to the privacy, of course, that's why he needed to replace the old fence.
Okay, thank you.
Thank you.
Thank you. Thank you so much.
I do see another hand raised. I'm promoting Marina.
Hello, could you raise your right hand to be sworn?
Yes,
Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
yes, I do.
Thank you, and state and spell your full name, please.
Okay. Marina, Marina. My last name Yacoub, Yacoub.
ACOUB.
Yacoub.
Could you
I am
spell that one more time? I'm sorry.
Marina, my first name,
Your last name.
Marina. My last name is Yacoub, Yacoub.
Thank you. Sorry.
Okay.
So I'm Michael's wife, and I just want to add something to what Michael said. Not only Michael had an anxiety about this issue, me too. Actually, I couldn't stop thinking about seeing someone going through the property or stealing something from us. Even during the night, I woke up too many times just to check if there's anybody sitting in the backyard or stealing something or watching us. And I saw them like too many times from the bathroom and kitchen window, and that was really scary. So having a higher fence, it gives me more secure and privacy, especially after having Layla. She's our daughter. She's like 1 year and 3 months. So yeah, we're really in critical needs for this, especially after having her. It gives us more secure and privacy, as I said. So I just want to say that he's not the only one got affected, me too.
Thank you.
Thank you.
So I'm just going to suggest that if the board is going to consider approving this variance with the heightened fence, what we should do is ground it in what is unusual about the lot. What is unusual about the lot is that there's no backyard and it's an unusual shape. So I just, you know, I don't know where my head's at on this, but we can't be setting a privacy precedent here. But I think it's appropriate if we consider that in light of the fact that it's an unusual plot and they have no backyard.
Yeah.
Mr. Chairman, and I'm looking at Google Earth there, and I guess the folks that are living at that property, the picture is before the fence was changed. So it looks like it's about 4 feet, but the house next door has a higher fence. So I think it looks like there are some issue with whatever our statute is, and enforcement of it. I don't know if it's selective or what, but it's a little confusing.
Yeah, I saw that too.
Commissioners, may I?
Yeah.
Okay. Yeah, Commissioner Dolly is absolutely correct. So when you're looking at C variances, there's 2 ways to look at it, right? The first is what we call the classic heart shape variance, which means that The lot is undersized, it's shallow, it's narrow, it's on a huge hill, it's near wetlands, which there are no wetlands in Jersey City necessarily. There are, but not on any 1 and 2 family lots, I don't think, I don't know. But that is like a classic C1 hardship variance. You see it, you know it's a hardship. There's the C2 variance, and that's explained as the benefits outweigh the detriments that are caused by the deviation from the standard. So where Commissioner Donnelly, I guess, is saying is that the difference here, what makes it, the variance has to be something that the site itself, right? And the search and the circumstance is unique and specific to the property. This is a corner property, and that's where I would say there's a minor difference, where the 4-foot fence was written for what you consider the standard 25 by 100 with only 1 frontage. This is 2 frontages. The next thing I'm going to say is that something you might not like, which is that almost every application tonight will tell you the same thing. They will be good people. They will not know that they needed permits. All of these things will come up tonight. And so I just kind of want to stress that because the situation is what it is and they're good people is not a reason to grant a variance. I'm just going to put it on the record and say that. It has to be based in planning reason. I know you looked in Google Earth and you saw something else that was a little bit higher, but it is actually not in Harmony. And the reason of security, yes, I understand what Mr. Solomon is saying, but that's not a planning reason. And there's no reason why a 4-foot versus a 5'8" fence would make a difference on security. So I do ask, when you are considering something, if you are going to consider voting in favor or against a variance, that's the kind of language that you want to use. You want to talk about how the site is unique, how the site is different, or how it isn't.
Tanya, is this the property that's on 440?
It's near 440.
It's near there.
It's okay, because the street
Doesn't
ends
follow.
on 440. It's not directly on 440 though?
It's not directly on 440.
Like a block away.
Yeah.
Okay. Because I mean, I guess I could see a hardship and it's not a security issue, but if I only had a front yard and I fronted onto the part of the property that fronted onto 440, it is a different situation than in half a block on the street. And maybe I'm not, Tanya, using the right technical terms, but
Oh, you're saying that's what makes it unique. That's what makes it different from maybe why a regular 4-foot fence would be required.
yeah, I mean, so if the rule is you have to have a max 4-foot fence, I could see giving a variance to something that's on like neighborhood commercial or whatever is 440, like a major road, to alleviate sound and a whole host of things. In a little bit, I personally don't see that there's a differentiation from a security perspective on any lot that's just on a block because it has only a front yard. My concern is there's probably a million lots that only have a front yard here, and then we would justify something that we're saying here is unique wouldn't really be unique, and there'd be lots of applications that would look very similar, if that makes sense.
And if I can just add to the conversation about enforcement, because Commissioner Green pointed up earlier, probably almost every one of these tonight is a result of a complaint. So we don't have enough inspectors to go out and do kind of spot and site enforcement. It's done primarily through C-Click-Fix.
All right. Let's move forward.
Anything anyone else wants to add? Does anyone want to make a motion? We can certainly do them separately. We have to vote on the appeal as well as the variance.
So to move it along, I mean, as we're talking about the appeal, I mean, it's straightforward. The appeal
Yep.
should be denied because the fence is higher than it should be. So
Yeah.
that's first, somebody should make a motion, I would think, concerning that aspect.
Okay, so I make a motion on Z 21-099 for 28 Mina Drive, for the approval of the appeal from the zoning, for the zoning of the, for the front yard fence exceeding the 4 feet high,
To deny the appeal.
to deny it.
Okay, is there a second for that?
Second,
Okay,
Commissioner Park,
yes.
Commissioner Green,
Yes.
Commissioner Donnelly,
Yes, to deny.
and Commissioner Arujo,
Yes.
and Chairman Jacobs.
Yes.
Okay, Vinny, I need help with this.
the appeal, the appeal of the zoning officer's decision is denied. All in favor, five for the denial, none to reverse his decision.
Okay.
So now that we've gotten that out of the way, at least Mr. Solomon has done this the right way, and now he's asking for a variance, for a fence that's higher than it should be. And you've heard the pros and cons of this, so can somebody make a motion? Maybe simply approving his variance, and then we go from there.
All right, so I make a motion on Z 21-099 to approve a C2 variance on the height that exceeds the 4 feet into the 5'7" height.
Great. Is there a second? We have a second?
Anyone can second, doesn't mean you're
Yeah.
voting yes or no.
I'll second.
Okay.
Okay, Commissioner Green,
This is a tough one. And I am torn because we are doing this on a C-click fixed basis and somebody next door has the same issue. And it seems like the inspector even called to that spot for a C-click fix would not just do that one, but do maybe the area. So I think we need some more clarity on this kind of thing. And if we approve it, then that's the specific one for the issues that were talked about as far as frontage, people being in fear, curtains may be doing the same thing. I would, I'm not even sure, how this is coming to us as a commission to do this. But I would vote no.
Commissioner Park,
No,
Commissioner Donnelly,
No, and I'm totally aligned with what Commissioner Green said.
and Commissioner Arujo.
I say yes. I think this is a unique case, and I think these people use their front yard because they have no backyard. And I think it behooves them to have a little privacy in their property. So I say yes.
And Chairman Jacobs.
I think you missed Commissioner Shadid.
Oh,
Well, when did Ahmed join?
Am I allowed to vote or?
I don't think Ahmed heard the entire, Ahmed, have you heard the entire thing? We didn't announce when you came.
I heard it when we start talking about the variance, well, not from the beginning.
So let's not have, let's, Commissioner Shadid is here. He's ready to vote for the next application, but not for this one.
Thank you.
Sorry.
Then we're left to you, Chairman, your vote, right? So got
Yeah, I'm voting no, mostly because I think that there's probably good reasons that from a policy perspective that the parties that make the code could look at evaluating nuanced changes for it. But this situation doesn't seem unique to me. I think there are similarly situated locations that I couldn't see justification for a variance in this particular situation. But I would encourage the appellant and their neighbors to reach out to their elected officials and champion for changes if they think they're appropriate.
Okay. In the motion of approval, the motion is denied. 1 in favor versus 4 opposed.
That's correct.
Okay. Thank you.
Okay, thank you, Mr. Solomon.
Thank you.
Thank you.
So we'll proceed with case Z22-056. The address is 83 Monitor Street. And let the record reflect that there's now 6 commissioners who will be voting. Commissioner Shadid joined during the last applicant.
Noted. Zachary.
Yes, hello. Can you see me?
Now I can. Could you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you can state and spell your full name for the witness, for the record.
Zachary Kozak, Zachary, last name Kozak, Kozak.
Thank you.
Mr. Kozak, you did notice for this case. When we
Yes,
have
yes, I did.
Notices and
Yes, I did.
David, your proof of publication. So Bridget, we're going to mark that as A1 for this application.
Thank you.
Okay, one moment. This will be A1 in evidence for this app. Okay.
Thank you. Mariam, I don't know if you're able to give us some good factual background here.
Definitely. There are 2 violations regarding this address. One, removal of front yard landscaping and the fact that 60% of the front yard needs to be landscaped. And another, which is off-street parking between the building line and the sidewalk, which is strictly prohibited.
Thank you.
So am I
Mr.
reading this right? This is just an appeal. There's no variance with this. Is that correct? I didn't see one.
I don't see one on
Correct.
the agenda.
I correct. I'm realizing that I believe that based on everything I've heard that this appeal is appropriate, and we can get into that, but I did not I guess mistakenly did not file a variance in the alternative. And so if I could make an oral motion to that effect, or if for whatever reason this appeal is denied, if I could proceed with a variance application, I just wanted to at least get that on the record. But I do believe that these appeals are appropriate, as I'll get into.
Yeah, we could hear the appeal. We can't hear the variance orally because you have to notice it. So
Understood.
let's hear the appeal, and then we'll go
Sure.
from.
Okay, so if we could just deal with the landscaping first, because that one actually, it appears to have been issued in error. This property was purchased in 2016 with the current conditions in place, meaning both the off-street parking and the current landscaping condition. Those conditions have not changed and have been exactly the same, at least since 2016, but we also know since since at least the prior owner. I was told at the time that we received the violation, I contacted Mr. Taylor, who issued the violation. This was not a C-click fix violation. And he told me that it was as a result of Google Street View and using 2007 as a basis for determining whether a condition is grandfathered in. And when you look at Google Street View, you will see that 83 Monitor Street did not have any landscaping. These are 3 houses, 83, 85, and 87 Monitor Street, that are attached. And it appears that the landscaping that's being referenced is in front of 85 Monitor Street. I spoke to Francisco, who I believe is on this call, about it, and also Mr. Taylor, and they, while not disagreeing, told me that I had to go through this appeal process. But I do believe it was issued in error, because when you look at Google Street View, I could see how one may think that the tree and bush in front of 85 Monitor Street, that they may think that that was actually in front of 83 Monitor Street, but there was never any landscaping, at least as far back as 2007.
Okay. Yeah, I don't know what to go off of, other than I'm looking at Google Street View, and I don't see anything in front of these buildings. But I don't know how to look retroactively. Yeah.
So if you look at Street View on the bottom of the address, it should say see other dates. And then I just went to 2007, which was the date that I was told was the basis for this violation. And if you do that, then you'll see landscaping only in front of 85 Monitor Street and no landscaping in front of 83 Monitor Street. And so I just think it was issued in error, which again, when you look at it, it's understandable why it would be confusing.
Chairman Jacobs, I can share my report. I do have some photos, so that way
Sure.
one can see.
And that was very helpful, Mr. Kozak. I now have a much greater understanding of Google Street View.
So
I just learned the same through this.
everyone can see my report. This is a photo from Google Street View from
Yeah.
August 2013. So
That's the one I'm looking at now. Yes. Amazing how different this street looks.
Oh yeah, exactly. Well, which goes to the rest of my appeal.
Those were good photograph, Francisco.
Oh,
So I don't know, Vinny, what is like the appropriate protocol here now? Like, I don't know, Mr. Kozak, if there's more that you wanted to say about the rest of the violation.
Well, about the parking, certainly, but about the landscaping, again, I was just told that the basis was this very street view that you're looking at, and that if it wasn't there in 07, then it's grandfathered in. And so as you can see, that therefore, it would have been grandfathered in, and the violation wouldn't have been appropriate. And again, I think they were looking at 85 Monitor Street, which has a tree and bush in front of it, and therefore citing 83 Monitor Street.
Okay. Yeah, I mean, I don't know, Francisco, you showed us something, and I'm seeing, it looks like the tree is there in August 2013. And the next picture I'm able to see is July 2018,
exactly,
which looks totally different, and there's no landscape.
Yeah.
Right. And again, the property was purchased this way, but the tree you're seeing in 2013 is 85 Monitor Street.
Yeah, I understand what you're saying.
Okay. Oh, okay, sure.
So did they get cited for this tree, 85 Monitor Street?
I don't know.
Yes,
okay.
a violation was issued. The applicant actually, I believe, was supposed to be on this meeting, but I think they have.
Right, that's the case that we adjourned. That's 9B.
I see, okay.
So, but let's get to Francisco, wherever you are there. What is the issue with 2007? So if Mr. Kozak is correct, the touchstone is 2007 for some reason? Is that what we're saying?
No, illegal, I'm going to chime in.
Yes, Marianne, sorry.
Parking between the building line and right of way.
No, first we're talking about the landscaping.
The landscaping,
back.
correct. Oh, I thought you were asking about the
No, right
parking.
now I'm asking about the landscaping. Is Mr. Kozak correct that somebody is pointing him to what it looked like in 2007? So if there's no tree there in 2007, he's grandfathered in for some reason.
So landscaping is not necessarily trees, and behind the fence, the wall that's there could have been landscaping. Unfortunately, we're not, it's not visible, and I'm assuming that, I mean, there could be landscaping behind that fence where there's no way to vouch for that specifically. However, 60% landscaping is required in all residential lots, and therefore, the violation, the 60% landscaping violation.
Right, but there's no such thing as, you know, if there was no landscaping in 2007, you're grandfathered in.
I do not believe so, no.
No, Francisco, or any such thing as that?
No.
Is Mr.
Okay, yeah, I mean, I think.
Is Mr. Taylor here? This
No.
is what I was told, and this goes directly to the parking as well. You know, and I was told that the reason 2007, look, I was surprised by it as well, that the city would be grandfathering based on Google Street View, but I was told that Google Street View, the earliest date is 2007, and that's what the city was utilizing to determine whether somebody is grandfathered in. So I guess without Mr. Taylor being here to confirm that that was the basis for the and in fact, if you look at 85 and 87, when we get to the parking now, you'll see 87 Monitor Street did not receive a notice of violation for the parking, even though the three are identical. The reason being supposedly was that in Google Street View, 87, they could clearly see had parking. So they said, therefore, only 83 and 85 got the violations. So even the way it's being applied currently seems to validate what I was being told, which is if it wasn't seen in Google Street View, then they're grandfathered in.
Yeah, it seems a little bizarre.
But if I remember correctly from Tanya, right, there is a 2001 change in the law, and then there's a year to abide.
Yes, yeah.
So I don't know where 2007 comes in. That's all I know.
Because that's
Well-
the earliest street view. And that's what I was told by Mr. Taylor was how the city was enforcing this, because there's obviously no way to know if the condition existed prior to the change in law. I was surprised by it, that would be the basis that, that the city would be operating on, but it certainly seems consistent because 87, as I said, 87 Monitor Street did not get a parking violation, but 85 did and 83 did. And again, the reason being this 2007 Google Street View. So,
Well, Mr. Kozak, I agree with you that sounds like a very crazy rationale for policy decisions. But Mariam can speak for the planning team and can tell us whether or not somehow Google Street View in 2007 allows the grandfathering in of if you have like your residential property is 100% concrete. For some reason, you're allowed to do that because it shows in an image. Mariam, is that the case?
That is not the case. It has been practiced at the Division of Zoning for a number of years that the earliest record that we have on file for any front yard parking or landscaping, depending on the situation, has been using, if there's nothing on record of any prior approvals, that is the earlier record that we have in place to utilize in order to be able to determine whether or not they can be grandfathered any type of carport driveway.
And when you say whether or not they can be grandfathered, what do you mean?
I need one speaker. You're talking over.
Sorry.
Repeat that, Miriam. What is the earlier record that you're referring to?
2007, the Google image that you're referring to. Yes, that's if you don't have anything on record in our files, that would be the essentially only document that we can go by and make sure whether or not that driveway or curb cut was there.
So what does that mean when you say it's grandfather? Does that mean if
by grandfather, it's
one speaker, please. Does that mean? Go ahead, Mr. Chairman.
Well, I just want to understand if it appears a certain way in an image in 2007, then the current owner would not be fined, or what is it used for?
it's a way to determine a pre-existing condition.
Okay, so what we're saying here is that if we determine that there's a pre-existing condition, which would be no vegetation and a car, then we would grant the appeal.
That is up to you and the zoning board. However, at the Division of Zoning, that would be something that would be taken into consideration to grant it pre-existing.
Okay, so
Chairman,
then
if I
why
can-
in this situation, sorry, yeah, Tanya.
Let me just add, the zoning officer's decision to use 2007, that's the only tool he has. And it's generous, right? So the reality is that in all appeals and all violations, it is the burden of the applicant to prove that it existed before it legally, when it was supposed to, which is before 2000. It's not our role to actually provide that. It is only the burden of the applicant. And so the zoning officer using 2007 being the only tool that we have, that he has, is actually being more generous.
Okay, and Miriam, if I understand what you were saying, there's no way to prove, and I think the same thing when I look at these images, that there wasn't vegetation behind a fence in August 2013. Is that
Right.
what you're saying?
Correct.
Well, no, you can look at the 07, all due respect, look at the 07 image and you can see there was no vegetation. And I'm just, I guess I'm a little surprised that an appeal and a zoning decision would be based on there could be. I guess I'm just dealing with what we were told. Again, this was not a condition that was changed. This was a condition that came with the property, has been openly utilized. As you know, this area at the time that this property was purchased in 2016 was a very different area, not a single building, all empty lots other than these three or blighted buildings. And so with all the construction happening, all of the zoning officials, the city officials going up and down that block, now there's so much construction, so many new buildings there. Never has a violation been issued, never, not once. We received 3 violations in the same day out of the blue at this time, including a violation from the city, from the prosecutor's office for cracked concrete on the sidewalk. And we were required to repair that within 35 days. The very same concrete that now we're being told needs to be turned into a curb cutout. So there's, based on everything that I've been hearing before, there's this condition was certainly existing in 2007. That it has not been changed. The applicant was not the one, that made the change, unlike other situations here. It's been openly utilized, and quite literally for 7 years almost since this property was purchased, there's not been a single violation. And so then all of a sudden, out of the blue, these conditions became violations. And when I called to inquire about them, I mean, I'm not making up 2007. If Mr. Taylor were here, I just don't know what else I can do to disprove or prove a negative from 2001. And if you look at the 2007 photo, you will clearly see there's absolutely no vegetation, landscaping, or anything else. There's in front of 83 Monitor. Again, it's only 85 Monitor. So
I don't think, Mr. Kozak, that's what Miriam is saying. I think that if I look at this picture from 2007, there's a fenced off area in front of 83 Monitor, and we cannot conclusively determine that there's not vegetation behind that fence. And then what I understand from Tanya is that the burden is on you to prove that something existed a certain way. And we can't conclusively determine that.
So then wouldn't you err on the side of, again, I disagree. You can conclusively determine that there's no vegetation. So that fence is what, about 2.5, 3 feet tall. So unless the claim is that, weeds growing behind that fence constitutes vegetation, I think it's pretty conclusive, especially considering that the bushes next to it exceed the height of the fences. Obviously, the tree exceeds the height of the fences. So it's pretty clear that there's no landscape coverage in 2007 or 2010 or 2012 and so on and so forth. So if ever there's a time for a pre-existing condition, I would just ask that you err on the side of the homeowner here, and I don't know how else to prove that something did or didn't exist in 2001. I'm just going based on the same criteria that I was told the city is using.
Mr. Chairman?
Yes.
Question. Now, if we're looking at 2007 as a baseline, does it really matter that it's vegetation or not if there was a fence up there and there was no parking at that particular time? Are we looking at illegal parking? Are we looking at vegetation? Because vegetation really doesn't count if we're talking about illegal parking.
I think there's two different issues.
There's two appeals. Yeah, there's two appeals. Two separate appeals.
But
This
I
is
mean,
just on the
yes,
landscaping
Tim,
issue.
obviously that's a very valid point. You can't park your car in that zone, in that area where the fence is.
Yeah, you can't.
And I think also that inspections needs to maybe do things in a systematic way, because if they're only coming out for a complaint or something like that, we need to be fair to everyone and take a look at these things at 2007 and see where are all the illegal parking spots. So inspections needs to beef up and do this thing in a systematic way so that they can look at 2007 and check these properties. So that's something that I would hope that be communicated to inspections, and not say that we're light. We don't have enough people to do this job.
I have a question. So whether it's 2001 or 2007, validating what was pre-existing does not actually automatically allow for something to be grandfathered in. Is that correct?
Are you asking me?
No.
No.
Okay.
But thank you.
I think that's for Tanya or Mary.
2007 is the base because that's the proof, the earliest proof of pictures for Google Earth. That's what I'm understanding.
Yeah, but Tanya or Miriam, if you could please answer that question for me.
I'm not sure if I followed your question. Do you mind repeating it?
My question is, whether we're having a lot of conversation around 2007. So whether it's 2007 or 2001, for my own edification, I'd like to understand if it were to be determined that the pre-existing conditions were there either in 2007 or 2001, does that automatically qualify for a grandfathering? Or does the burden of the proof need to still exist with the property owner as to what they choose to do with their property?
If there's documentation that the use was deemed pre-existing, whether it's through the zoning officer or the zoning board, then they're grandfathered in. However, if the use is at any point, I'm not saying this is the case in this situation, is abandoned, it's no longer valid.
If I could just add to that, very technically, you only get a grandfathering condition if you got it legally when it was permitted. But however, or if there wasn't a time when there was a rule around that. That's just another step.
Yeah.
On the other hand, I don't know.
I do see Commissioner Donnelly's hand is raised. I can't.
Can you hear me?
Yes, now I can hear you, but I couldn't hear you before.
Because I've been trying. So an issue that I have is that the notice of violation itself uses the Google 2007 map as one of its proofs. So the decision is actually, it states in the notice of violation that it's based on the Google Maps. When you look at the Google Maps, the Google Maps indicate that this existed in 2007. So then I kind of think that the basis for the citation itself kind of is an error. Because if you're going to live by Google Maps, then you're going to die by Google Maps. And I do think that, you know, on his appeal, Mr. Kozak has demonstrated that those conditions existed in 2007.
Just to clarify, the conditions didn't exist in 2007. There was no parking nor.
We're talking about landscaping now, right? Yeah.
Yes.
Yes, I haven't addressed the parking yet. There's two. I filed two separate appeals.
Okay. I mean, I think that it.
I have one more. So I
Yes,
just have
go
one more. So I would like to say that, you know, back in 2007, weeds really does constitute of landscaping because there was nothing there. So like, let's be clear, right? The question I have is, if you were to measure the property, that the backyard, whether it's all weeds or not, it doesn't equal the 60% required, correct?
Just to do a clarification, 60% is in the front yard, not in the rear. 60% of the front yard needs to be landscaped.
Okay, thank you for that.
I mean, do we know what landscape, does landscape have a clear definition that is
Why does-
explained?
That it drains.
Okay,
So that's the purpose of it. I mean, it also makes it look nice, but it also provides drainage.
okay, so it doesn't have to be a tree or a bush over a certain height. I mean, a fenced off area, I would rather that it be vegetation than a fenced off area of concrete. I mean, this is like absolute insanity to me that we're somehow making decisions off of Google Maps in 2007, and this seems to be legitimately how the city operates.
So
But
I do want to make it clear to the board that not only was it in 2007, but it was apparent up until 2013. So I shared it earlier, but
yep,
there was some sort of something in the front.
But what was behind that? What's behind that fence?
we don't
Can't really tell.
Don't know.
Nobody knows.
Nobody knows other than if the owner would have an image, and in this case, this would be the owner's responsibility to prove to the board that there was something behind there, because it was existing in 2013.
This looks beautiful.
What was existing in 2013? Not landscaping though.
So
We
the-
don't know.
Exactly.
Yeah, it's like.
point
a-
is, yes, so
you
we
have a-
have no idea.
Yeah. Maybe the owner did that just for privacy or something as well.
It could be for privacy. It could be for.
Be an herb garden.
You can just put a whole bunch of pots. and making
The
you know,
speculation is maybe making this a little longer. Can we get to the point and
Yeah.
say what we're going to do with these two appeals, break them up and say,
Yeah.
Can we
Yeah.
just say them? Yeah.
we don't know.
Can I ask a question, please?
Yes.
Looking at the picture on 213, it seemed like that green wood or fence, it's covering the stairs.
Yeah.
Yes,
Maybe
correct.
where is the entrance to that house? So
Yes,
maybe
there's stairs there.
temporary, maybe there was something temporary, and just happened to have the Google map taken that picture.
I don't think there's greenery behind that.
Because I compare the two pictures, there is no steps going to the house.
Yeah, the steps are the steps are to the right of the green, to the top floor, and then
Yeah, so
behind the green are steps going downstairs. And the green is there in every picture. Looks like 2007, 2012, and 2013. The green is there, so it's definitely at least.
My point, Mr. Kulak, is there is something hiding the steps and hiding the vegetarian behind that, if there is any. Nobody can determine exactly what is behind the green fence.
Yep, nobody.
So that could be something temporary. It's not really a fact. It cannot
Yeah.
be there forever.
Maybe garbage cans or something that somebody
Yeah.
wants to hide behind that cement wall. It doesn't show that there's any landscaping at all.
No, and I think Ahmed, to your point, I mean, as I inspect all of these iterations of Google Maps, now that I've been educated by Mr. Kozak about the features of Google Maps, the one from September 2012, I can get the best view of the like doorway to the stairs. You can see enough that it looks like it's all concrete or paved on the ground. There's no way Mr. Kozak is not the owner of the property from that period of time, would be in any better position than us to determine what was there. But it doesn't look like there's anything. So I agree though that with Kim, like, I don't know if you guys want to break this up, if you want to hear more on the other one. I mean, I'm inclined to say, like, there's concrete there, there's no vegetation.
Let it go.
I don't see how we know enough to say anything different.
Mm-hmm.
So, I mean, granting the appeal. Do you guys want to vote on that, or should we hear about the other one first?
We have the public, maybe there's.
Yeah, we'll hear from the public. But I mean, I don't want to open it up to the public twice.
You want to talk about the other one as well?
Yeah,
The other-
I think we
other
should talk about the other one first, and then we'll probably vote on each separately.
Okay.
Okay, sure.
Um,
Yes, and if we could, if that would be possible to vote on them separately, as I did file them separately, I think they were just combined for ease of this meeting. But obviously, they were separate noted violations and separate appeals. So on the parking, so a lot of similar facts. Again, this was not a condition that we changed. This was a condition that existed on these three properties. As I said, and I think you could check your records, only 83 and 85 received a notice of violation for this parking issue, but not 87. Again, identical properties, identical situations. If you look at the curb cutouts, not just on these properties, but on at least half the properties on this one block alone, they all have curb cutouts and parking. And so the arbitrary manner in which this is being applied, again, based on Google Street Maps or Street View, whatever it's called, this was a condition that we purchased the property with, and again, parked in that spot for at least the last 7 years, while this whole area was obviously being inspected left and right by the city with all of the buildings going up. And it was not a see-click fix issue. This appears, look, I was told when I inquired as to why this all of a sudden occurred, was that there was an opening of one of the new buildings next door, and somebody in city government directed someone in zoning to go do something about those spots. Now, that's very different from see-click fix. I don't know what we did to get the attention or ire of anybody in the city, but again, this condition is not something that we created, and the fact that it's still being arbitrarily applied, these three identical houses, attached houses, and that only 83 and 85 received this violation, and not 87 or half the other houses on this block, it just leads to a very arbitrary application of this rule. And then you still get into the same issue when you look at the old curb cutouts, when you look at the old imaging, the same condition existed in all of these pictures. So it's similar, but slightly different situation. But you still get something, a condition that has that has been there certainly since we purchased property, the entire time since, appears to have been there prior as well. And even today, the city seems to be applying it in an uneven fashion. In fact, many of the new buildings that went up received new curb cutouts as our neighboring buildings. And so while now I understand that I may have to apply for a variance, I just, hearing the other applications, just think that this is very different, because again, this is not a condition that we created. This is a condition that has existed for what appears at least a decade and is consistent with many of the other properties on this block, single family homes, multifamily homes. If you go up and down Google Street View, which appears to be the basis, you'll see half the properties having and parking in front of the house, and again, as well as our neighboring identical building. So I guess the point I'm making here is that not only do we believe it's grandfathered in, but I guess how can our identical neighboring property not have received a violation and be told is grandfathered in when ours is not? And I don't want to get anybody else in trouble. Far from it. I just want to have an equal application to us as all the other properties on the street, and as our neighbor. So, yeah, I'm happy to answer questions, but that's the general gist of it is that really just kind of we're taken aback by this whole process, having been there so long and having purchased the property with these conditions.
Okay, thank you. I think this one, so I think I'm more sympathetic on the first one than on the parking one. And I don't mean that to say I'm not sympathetic, Mr. Kozak. I think what I mean is I think the board is relatively hamstrung on our I think these are very fact-based in terms of these whether or not there's like a violation, and that I would encourage you to seek a variance, which you said at the outset you understand procedurally you didn't do, but you would like to do. I mean, that's kind of my view, is that I think that the first one, like I feel okay with my reading of visually Google Maps, that it was all concrete. This one, it wasn't a parked car in 2007 or 2013. But I think that you might have a sympathetic board for a variance. But I would deny this appeal. I don't know, does anyone else see this differently? And Tanya and Mariam, you can explain to me that my reading of this is incorrect.
I'd just like to add that that it's homeowners' responsibility to ensure, to provide proof that whether or not a condition existed prior to the regulation passing. And if that information is provided to us, we're more than welcome to work with the applicant, Division of Zoning, and change the violation.
That's true, but just to kind of flip this over, it's why is the burden on the property owner, since it's their property, to be able to put this timeline together, especially given the fact that this one condition, it may have existed since 2007, and why is this important now? It's hard to understand the consistency of the enforcement.
And I think also that there is a lot of new owners in Jersey City now, and how are they gonna prove something happened a few years ago or 10 years ago or 15? It's we buy the house, you buy it the way they existed. If there is a violation or not.
So I think that's when it comes into play, where the homeowner needs to do their due diligence and do a little bit of research and figure out whether a curb cut or etc. was legal, and the city does have a record of it.
But who thinks of that? Like, you get like a home inspection, you do a title search. No one would also ask for this.
There was no open violations, I can assure you.
When you're
yeah, I
investing
mean,
in
and
hundreds of thousands of dollars, I would hope
But-
that would be the first thing.
well, but again, I think this is where the context of the property, it was Armageddon down there. We were ahead of the curve, right? I mean, there was nothing but open, empty, dilapidated lots. So I have to be honest, the thought that somehow the curb cutout, which again existed and which existed on our two neighboring properties and half the properties on the street, you know, I don't know how else to respond to that other than it feels like a bit of an undue burden. And I mean, if you look, I mean, the other thing is, and well, I'll leave it at that. It's just that we purchased the property, you know, turns out we purchased the property from somebody who directly is involved in all of this. And so we had even less reason to think that this would be any kind of zoning violation. And so if it's not going to be applied to people that work in the city, then how could it be applied to us? It just, yeah, the entire thing feels like it's being arbitrarily applied. And I understand this is a difficult one for the board. But it's, you know, again, this is how we purchased it. There was nothing else around. We've never changed it. The cars have been out there for the last 7 years, and everybody has gone by. I mean, all those new buildings that go up, all the inspections that go up that happen there, and then all of a sudden someone is directed to go, you know, I don't know, to say that we could have figured that out, you know, just as easily. The person who we bought it from, who literally, you know, worked for the city. It's like, you know, in zoning, I would never think that would be an issue. I understand that's not black letter law, but I just hope that it gives you a little context as to
I just
what our
wanna-
mindset.
I just want to cut in here. Please, I never say anything like this, but it was not Armageddon. There were thousands of people that live there. That area has a huge and rich history. Please, like, so.
No, not Bergen Lafayette.
Like, I never say this. I never say anything like this, but you didn't buy into Armageddon. So
I'm sorry if I overstated. Not Bergen Lafayette, not at all. That one square block, there were no other houses or no other buildings. That's all I meant. We were those three houses, 83, 85, and 87, were literally the only standing structures that were not like condemned or empty lots. That's all I meant. I didn't mean to overstate the whole area. I just meant our one block. That's all I was referring to. We were the only standing structures.
Mr. Kozak,
Yes.
have you done any home improvements since 2016?
Since 2016.
Since you purchased, let me just clarify, since you
Yeah.
purchased, which you said you purchased in 2016.
Correct. I mean, you know, we changed
Mr.
kitchen
Kozak,
countertops and things like
Mr.
that, but
Kozak, I think what she's asking you, did you do anything where
sorry.
you would have invited, where a building inspector would have to come into your property to review a bid or something like that? Did you ever take out a
the
permit?
only thing I could think of is, yeah, I think the front stairs were rebuilt and the contractor pulled a permit on that. I think that's the only thing that I can think of right now.
So it would be safe
Yeah.
to assume that you perhaps looked into some of the front area requirements to have that.
No.
Or-
No, I didn't. not
Sorry,
at all.
Mr. Kozak, or the person that you paid to do that work would have been responsible for getting permit and understanding the regulations.
Oh, well, again, it was literally just rebuilding the front stairs. So, no, I don't expect that they would. It wasn't a lawyer, you know, I know they pulled a permit, but I don't expect that they would have been looking in, at the parking conditions or anything like that, because we didn't do anything with that, nor did we ask them to. It was never touched. It was just those front stairs were falling down and we had to rebuild them. So, it was a very limited, engagement, for that work.
Yeah, I mean, and Veronica, I think that's I think it's unreasonable to kind of like, I mean, there's so many building projects that you would do that is unless they touched like the front part of the house.
But that's what we're just saying.
Anyone would look into.
Chairman,
We did
it's-
not. Yeah, we did
It's
not.
the front, I mean, the front stairs are attached to the front of the house and require, I mean, I'm just trying to understand really, Mr. Kozak, how uninformed you were, based on the fact that you
Completely.
area that was being developed in 2016, and that you have perhaps done some renovations and some updates to your home, and so
Yeah.
completely blind to what the city regulations are, I just struggle with a little bit, especially now knowing that you
Well-
did work with where permits were pulled. Let me just finish, and then you're welcome to have the floor again.
Sure. Sorry.
That's okay, you can go.
Oh, just so completely blind. Again, with the stairs the front stairs were crumbling. All we were thinking was we need to rebuild the front stairs. The parking existed. If we were building parking, I would completely agree with you. And I would say, hey, either our attorney or I, or somebody needs to figure out if this is allowed. But we purchased it this way and again, continue to use it openly for all of these years. And then all of a sudden find out so I was completely blindsided when we received these violations. It was shocking to me. So, I don't know, rebuilding the stairs and having a contractor do that wouldn't even cross my mind to think, well, let me, are there other violations? I mean, again, because these conditions existed and continue to exist. So, and we're not the only ones. This is the whole thing. Even now, I just have to go back to the violations were only issued for 2 out of the 3 identical properties. So even now, it doesn't seem that the city is able to apply it equally. It still seems arbitrarily applied. And so, no, it never would have dawned on me that there was no open violations when we purchased it. We didn't change anything. It never would have dawned on me that parking there for the last 7 years was a violation.
Okay. I mean, I don't know what else we can add. Like, look, like we can see visually what we have to go on. I think that's all there is to vote on. What do we think was there? Do we think that's sufficient for grandfathering these 2 separate conditions? I'm not trying to cut anybody off, but why don't we hear from the public? If people then want to discuss more, let's do it.
At this time, I do not see any hands raised, but for those that are in the public, if you do have any questions or comments, please press raise hand button. I do see one hand raised.
Only about 83 Monitor Street. I don't want to hear any other questions or comments from the public unless they pertain to this appeal. So, Francisco, is anybody coming forward?
Yes, they are
Okay.
actually panelists.
Okay, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, Verghese Thanjan, 70 Morris Street. To the
Could
chairman,
you state and spell your full name, please?
yes, it's listed under as you see it, VERGHESC, first name, last name, THANJAN. With the
And your address
chairman's comment, I wouldn't have raised my hand. I would have tried to lower it, but I already got in. It was only supposed to be specific to this property, 83 Monitor Street. But I must say to the commission that you do have a very, very difficult task on your hands because it's specific to 83 Monitor Street, but it does set sort of a precedence throughout Jersey City. So good luck to you all. Basically, our parking in front of homes, lack of green space, etc. It's a big can of worms that's on your plate. So I hope you guys solve it. Sorry. With your chairman, with your comment, I can't really say anything else other than that. So best of luck, you guys.
All right,
Thank you.
Thank you.
Bye.
I do not see any hands
Mr.
raised.
Chairman, are we
Yes.
correcting the time with the public?
We're closing the public, right? There's no other
There's
comments?
no other hands raised.
Oh, okay.
Oh, no, I meant there's no hands at all.
Okay, so we're
Close the
closing the public portion of this application. Ahmed?
Yes, I'm saying that I don't know if there is another case or not, but are we tracking the time?
No, not
For
now.
the-
Public
for the
is
public.
closed. for the next case, we'll track.
Yeah,
the
okay. That's fine.
Okay.
So are we?
Staff,
Talk to
anything?
staff? Mhm.
Yeah, staff, anything that you want to add? I mean, I think that we've kind of been interspersing some comments, and the burden is on the homeowner under the standard we have to prove that the conditions didn't pre-exist 2001. Is that correct?
Yes.
And if the homeowner cannot meet that burden under the letter of the law, there's a violation, and we have no grounds to overturn a violation, correct?
That's correct.
And that if an applicant seeks to challenge the condition, if they cannot meet their burden to prove that something pre-existed, the avenue to do it is not to necessarily appeal, but to seek a variance to say that given condition or hardship, that their condition is exceptional and they should be given some, some lenience. Is that correct?
Yes.
So is the position of the staff that given that, and given that the homeowner is not able to meet their burden, that the correct thing to do here is to deny both appeals, and then the homeowner has an opportunity to seek a variance.
Yes.
Okay. Anyone have any questions?
May I say-
for the staff?
Yeah, Mr.
May I
Kozak,
s-
I think.
May I
might
say
have-
one last thing before you vote?
Well, I was gonna say, Mr. Kozak.
Yeah,
you may have
yeah,
made your
so
case
now
for the-
I'm sorry, I need one speaker, please. If everyone could not talk over one another, that would be great for a clean record.
What I was saying, Mr. Kozak, was that you appeared to make your case for the first appeal, your front yard, based on the 2007 photo. I think that's what some of the board felt. I don't know. But I don't know how you want to deal with that, Mr. Chairman. You one vote on one vote on the other? Or-
Yeah, I think we should vote on them separately.
Yeah,
Okay. So let's start with the appeal of the violation that less than 60% of the front yard is landscaped.
mhm.
And that's based on, as Mr. Kozak pointed out to us, a 2007 Google map, which seems to say that it was never landscaped. It wasn't landscaped at that point,
Mhm.
what the photo looks like, but I don't know if any, I would assume if you agree with that photo and Mr. Kozak's interpretation of that photo, you would be making a motion to uphold his appeal, which means you're reversing the zoning officer. That makes sense?
Yes. So anyone want to make a motion to uphold the appeal on the 60% coverage?
Mr. Chairman, I'd like to make a motion to approve the appeal on the 60% of front coverage. Looking at that picture from 2007, that's inconclusive and I think problematic. So I would move to support the appeal.
I second that.
And a motion to uphold the appeal, reversing the zoning officer's violation. Commissioner Shadid,
Yes.
Commissioner Green,
Yes.
Commissioner Park,
No.
Commissioner Donnelly,
Yes.
Commissioner Arujo. Oh, I couldn't hear you.
Yes,
And Chairman Jacobs.
No.
Okay. Motion carries 4 in favor, 2 opposed. So the motion, the appeal is upheld.
Yes.
Okay. Does anyone want to make a motion to uphold or deny the appeal on the parking?
No, before we say that, I'm sorry, that we don't, in these cases, we don't need 5 votes, the majority,
No, it's majority in this case.
majority, oh, okay. Okay.
Mr. Chairman, I would like to deny the appeal of the parking in the front yard based on the 2007 pictures of this property. And if we're using that as the basis of it, I would move to not move against the appeal.
Does anyone want to second the motion to deny the appeal on parking?
I'll second the motion to deny the appeal.
Okay, on a motion to uphold the zoning officer's violation, which is a denial, is Shadid? Commissioner Shadid?
No.
Commissioner Green?
Yes.
Commissioner Park?
Yes.
Commissioner Donnelly?
I'm voting yes to deny the appeal, but I would also be open to approving the variance, especially if the city does not apply equal enforcement to the 3 properties.
Commissioner Arujo?
I vote yes to, what is it, not to approve the appeal, but I feel like, you know, I can agree with Kate. This should have been across the board to all 3 properties. And by the way, it looks beautiful. So I really want you to come back to get, you know, a variance on that, because you've done very well on your property and it looks really, really beautiful. So good luck.
Thank you.
And Chairman Jacobs?
Yes, and I agree with all the sentiments of raised by Commissioner Donnelly. What I would say is, I guess this is my first experience with understanding that the city seems to make decisions based on Google Map views, and I would hope that we seek different ways of policy enforcement, but absolutely we should seek uniform enforcement. To me, it would seem beyond crazy and arbitrary if because of a map view from 10 years ago or 15 years ago, we were seeking different treatment of these 3 properties because in a picture there seems to be a driveway and a car, and in a different one there seems to be a tree. So we need to have a better process as a city.
Motion carries 5 in favor, 1 opposed.
Thank you, everyone, for your time.
Kozak, we'll see you again, I guess.
Mr. Chairman, I
Yes.
have an issue
Again, Mr.
of consistency of, you know, if we have illegal parking, are the inspectors going to be going out to all the properties and looking at them based on that 2007 picture?
I have no idea. That's why this should be handled by variance, because then it would be documented appropriately, and then the planners wouldn't be going after the properties.
Mr. Chairman, why don't we give Bridget a break?
Okay.
Yeah.
So we'll take a 5-minute break and we'll resume with case Z22-085, which is 4 Highview Road.
Okay. See you a little after 8:30.
Ben, is there anyone else you would like me to promote?
I think I'm good for now. I think
Okay.
this is a it's going to be a legal argument, so
Okay.
go from there.
Are you ready, Josh? You're on.
Yes, sorry. So anytime we're ready to get started, let's go.
I think we're ready.
Okay. Good evening, Mr. Chair, Commissioners. Good to see everybody as always. Chairman, good to see you. I've missed you the last couple times I've been here, so good to see you. I just want to make sure, did you call our case formally yet? Did you need to
No, he
do that?
did not. I was just.
Oh, I'm sorry. I thought sorry. This is case Z 22-085 for Highview Road.
Okay, thank you,
Mr.
Mr.
Wine,
Chair.
this is a notice case. You've noticed we have your affidavit of service, your proof of publication. Bridget, we're gonna mark that as A1.
Okay.
Hi, this will be A1 in evidence for this application. Vinny, did we have A1 for Mr. Kozak too? Okay,
Yes, we did. I did put that on the record.
okay, thank you. A1.
All right.
So,
Thanks,
Mr. Wine,
Mr.
to make
Lepaglia.
this simple, we have two appeals here. And I understand you're gonna withdraw the first appeal?
Yes, and that's what I was going to get at first and foremost. I'll just put on the record that when I agreed to be retained to take this case, and I did a little bit of due diligence and took a look at the violations in question, I made a determination, and to be clear, my client had already filed the appeal to preserve his time and all that, but I made the determination that the zoning officer's decision about a violation regarding operation of an illegal bed and breakfast and spa, I'm certainly not going to dispute that as a matter of zoning as to whether or not that's permitted in the R1 zone. I think it's pretty safe to say that it would not be. So I said, to my client, Mr. Garvin, this is a matter for the courts. I'm not comfortable appealing that decision, to the extent that you'd like to take this up as a matter, and fight it out in court as a factual matter as to whether or not you did in fact operate this illegally. That's a matter for the courts. I'm not appealing the determination of the zoning officer that such a use cannot be permitted in the R1. So I would just like to put that on the record that I'll not be seeking to prosecute that appeal this evening. For everybody's knowledge. The second appeal, which Mr. Lepaglia alluded to, is the one that we're going to talk about this evening, and that's regarding the violation letter regarding excessive work conducted without zoning approval. So I'm gonna flip this into two different avenues here. First and foremost, I'm going to say it's a facial appeal. It's an appeal of the denial letter altogether, which I'll get into why and whether or not it should have been issued. And then we'll walk through afterwards, if the board were to think after my hopefully compelling argument, if they were still to think that the letter may have been issued correctly, we can walk through the individual facets of that letter as to why the particular issues raised are individually not in fact violations of the zoning ordinance. But on a facial basis, what I just want to indicate is, and give a little bit of brief history here. So my client has owned this property for a number of years, and back in 2017, filed an initial zoning permit application and subsequent building permit applications to renovate the existing house that was on the property. That was back in 2017. Permits were approved. We've been through the portal. There doesn't seem to be an issue in that regard. Fast forward through the construction project in early 2019, an additional zoning permit was filed, and additional construction permits, plumbing permits, electrical, all the works to actually expand the existing structure that was there on the site. Plans were filed with that. Approvals were granted by both zoning and the building department and plumbing and all the relevant subcode officials at that time. Again, no issues at that time. Since 2019, there have been, and this is not an exaggeration, and I'm sure Ms. Marion might be able to back me up on this, but dozens of what I'll call field changes that are standard and typical, some of which, you might have less on a different project, but throughout the actual construction in accordance with the 2019 approval, changes in materials used for plumbing and changes in hot water heater infrastructure and things of that nature, changes to interior layouts. These are standard things that happen during field changes during construction. And throughout that process, as is standard and required in Jersey City, updated permits were filed on the portal system. And I'm not sure how familiar everybody on the board is with the portal system. I know it's more of a building kind of contractor user situation. But again, all of those updates were filed. You can see if you go through the history, which we did Oprah as well, there were a number of things where there were approvals issued, there were denials for not meeting certain subcode requirements, kind of standard throughout a construction process. Ultimately, the property was completed based on those permits that were received in early 2021, at which point the first iteration of a zoning denial was issued in February of 2021, saying simply, this cannot be converted to a two-family use. That was all that it said. And subsequently, 3 months later, in May of 2021, with a little bit more explanation, it was also indicated that there were also potential zoning concerns regarding setbacks, a pool on the property. But I highlight this to say that all of those issues, every single thing that's there, the pool, the structure itself, were shown on the plans that were submitted throughout time between zoning and the building department portal. They were consistently shown through multiple iterations, but they were shown. Permits were received, and in good faith, everything was submitted as it should have been. So back in what I'll say February to May of 2021 was the first iteration. What my client then did at that point was have a little bit of confusion because he's got a completed building that he has permits for everything, and now he wasn't sure really what to do. But he ultimately proceeded to continue to file what I'll call simple permit revisions, again, for plumbing related issues, completely unrelated to zoning, just to get the building finalized. Again, there was I think it was a hot water heater swap out. There was something about an HVAC unit that needed to be changed, but again, nothing that would impact zoning, have any issue with zoning. He just at that point wanted to complete, the building at that point. And that was all done. In late 2022, when the building was ready for receipt of a certificate of occupancy, and again, not focusing on the issue regarding, an alleged use of the property as a bed and breakfast. I'm not here to discuss that. But when a CO was ready to be applied for the actual structure and ultimately the 1 or 2 family use, as this is the R1 zone, a CO was not granted and a denial letter was issued, which we can walk through the specifics, but that is the denial letter in question that I'm here appealing this evening. I also want to indicate on the record that at no point from our review, and again, we did file an Oprah request. Ms. Marione actually provided a very detailed breakdown. There's a timeline that she provided that includes, and I'll walk through that shortly, but at no point was there a stop work order issue. At no point were there any issues with the permit saying, with the building permit saying this is not what is shown on the plans. At no point did any of these come up. And my client, as a contractor, going through the portal system, really did everything the way it could be expected to be done. And based on the law, why I'm saying this is what I'll call a facial challenge to the zoning officer's 2022 denial is when you have permits issued in good faith, and I can offer the citation if the board would like, you have a right to rely on those permits. And whether they were issued appropriately or not, and I'll contest that they were appropriate anyways, but even if not, as long as they were applied for, sought, and complied with in good faith, there is case law to the effect of you have a right to rely on those permits. And again, we can get into that in a little bit more detail.
So, Mr. Wine, if it's possible, I just want to interject. It sounds to me, based on the, I think, very valid, but many points you've made, that there's a lot of issues of fact and law that might be present here that really differentiate the nature of this appeal from some of the other ones that we've heard today. And I'm pausing you because I'm not sure I feel that it's appropriate for the zoning board. If I were your client, I would say, there's probably issues of discovery, and maybe a judge would be a better avenue for seeking justice here, teed up against the municipal prosecutor's office. So I'm in no way trying to punt things. I honestly think that we're not being fair to your client by being the body that adjudicates this. But I'm sure I'll be told different things. I don't know, Vinny, Tanya, if you have different views, or maybe I'm contradicting something I've previously said.
I'm not sure if they want to weigh in on that. I appreciate what I'll let them weigh in, but then I'm happy to also weigh in.
I mean, all those extra years of school, I did not get a law degree, so I'm not going to weigh in on anything like that. But I would say that the board does have the ability to read the interpretation, judge whether or not they were correct. The interpretations are violations. The violation, I think the one that's specific that Mr. Wine's speaking to is the excessive work. And that's probably, I think, Chairman, what you're more referring to.
Yeah, so this one's of a pretty different nature than I look at a picture. Is there a fence that's over 4 feet? Here, like there's this one takes some like nuance, and I don't know. You're right. It is like a decision of a zoning officer, so it's somewhat similar, but it seems to be of a very different character.
Understood. And I'm happy to let Mr. LaPaglia weigh in. You know, you mentioned going to the courts. Realistically, this is the avenue of appeal of a zoning officer's determination. And when you go to the courts, what they would typically turn around and say in this situation is, well, have you exhausted all of your remedies available to you at the municipal level? And my response would have to be, if that happened, if we, let's say, went forward tonight and the appeal was denied and we did that, then I'd be able to say to the judge, yes, we did. The board denied the appeal, and that's why we're appealing the appeal to the court. But at that point, that's what a judge, I believe, based on my reading of the law and the appeal process, would say. So I believe with that in mind, it is the board's jurisdiction. And you're right, there is an issue of fact here, but I would also go so far, and I heard in the last case that I was listening to as well, it's our duty, and I don't think this changes, it's our burden of proof to prove that fact to you, which what we can do, and it's referenced in my whole list of notes, which I'll get to in my timeline. It's also referenced in the timeline in the staff report that's submitted, but we filed an Oprah request for everything. And we did that, you know, and got responses. And I believe the staff report also had an attachment with all of the documents on file as well. And I give credit to Miss Marione, because this took me about 20 hours to get to the bottom of, which I can bill my client for. Miss Marione presumably can't do that. So, you know, I give her a lot of credit for the amount of time she spent on this. Realistically, the facts are what the facts are. We have the plans, we have the stamp from the building department, we have the portal records, we have all of that. And when we then get issued a zoning denial a year after construction was completed, when all of the appropriate steps were followed, what the basis for my appeal is not necessarily, and again, the second part of my appeal might be that whether the zoning officer is correct or not, but the first part of my appeal is, do we have a right to rely on the permits that we've received? And that is in my opinion, it's a legal issue that this board does have jurisdiction to weigh in.
Okay, great. I want to make sure you felt comfortable. I certainly want you to make your case as much as you can. I want to fast track this as much as we can, though, if possible. It sounds to me like you've got a lot of documentary evidence. Planning probably will go through that as well. I'm inclined, based on that, to uphold the appeal.
And I would certainly appreciate that. I'm not sure if there were any other board comments, or if you wanted me to display the 150 pages of permits that we can. I'll leave it to you. I'm not trying to be coy. I just want to make
I understand.
Sure.
I mean, that's my point. Is at what point do we like? This is something that's very unfamiliar to us, and I really don't want to go through 150 pages of documentation. So, Vinny, do you think, what am I doing here?
The point being from Mr. Wine is this: his client does have a right to rely on the permits that were issued.
Yes.
Here he goes, and now he's finished his job. He's going to get a CO. and somebody says he's done work excessively. It doesn't make any sense to me.
I agree, Vinny, which is why I think that we don't need to go into any more detail. I hear the argument. I think the argument is meritorious. But I mean, where I'm struggling, I guess to some extent, but I guess I'm being told I'm thinking too much about this, is that I don't think I want us to go through the facts of this to determine whether or not that's completely truthful. I just want to rely on what Mr. Wine has said, and not have every piece of thing produced as evidence and reviewed and discussed. And if we can do that, I'm happy to be done with this.
Well, should we hear from what Marianne has to say? Is that at the risk of not? Go ahead.
Well, there's a lot to be shared. I think the best way to go through this is perhaps to share the timeline that the staff has created for everyone, just to get an idea of what's the background. And then I can chime in.
Okay.
That works. So I mean, I'll defer to Ms. Marione's report. I'm happy to share it, but if she'd like to share that, we can put it up on the screen.
Well, I apologize, Miriam. I totally forgot. So, do you want to make your argument as to what's the basis here?
Again, I think it would make more sense if we look at the timeline, because some of the information that was shared, I'd like to discuss about the timeline that is being discussed. I'll give a general overview. The project did receive zoning approval in October of 2017 and in January of 2019. In none of these applications, there were any of the issues that rose within the determination letter and subsequent the violations. There were subsequent plans that were submitted to our office in 2021, which we assume that there are applications for permit to build these specific proposals that they had, including I'm not sure if I should go into the details, but including a pool in the cellar level and certain expansions into rear yard setbacks, and a couple of other issues with the project. It was then that it was denied. The applicant applied again for a plan review. It was denied. A zoning determination was provided. It wasn't after few inspections and violations that we actually received an application for a certificate of occupancy, even though all the applications have been denied by the Division of Zoning. So I just want to make that clear, that there were no approvals for what is being proposed and what they had received violations for.
And to that point, to Ms. Yagubi's point, again, they were submitted through the portal system. I'm not going to belabor the point. I'll let Ms. Marione go through the timeline. But again, my argument here is a right to rely on the permits that were received. So what I'm getting at is, and we can talk about the specifics if you want, but what I'm getting at is, even if the permits were issued in error, and I'm suggesting they were not, but even if they were, legally, my client has a right to rely on those, and it's up to, but whether the building department and zoning department were communicating or not communicating, should have been, shouldn't have been, the portal went to this person's eyes, not that person's eyes. That's kind of beside the point. That's why I started by saying this is a facial challenge, that if permits were issued in good faith, plans had been submitted, the portal is the process in Jersey City, that had continued to be, the building department continued to issue permits in accordance with plans that were revised multiple times, we have a right to rely on those permits. That's again, without getting into the specifics, and then we can do that later if the board so chooses, we can go through the specifics, but my initial challenge is based on having the right to rely on permits that were received between 2019, but I should say between 2019, actually between 2017, and ultimately when the building was completed in 2021, only at that point when that first zoning denial letter was issued.
I will also add that applicant had applied for zoning application and permit review through Division of Zoning prior. The applicant is familiar that the portal is not for the Division of Zoning, but it's for the building.
I'm sorry, I didn't get that, Miriam. The applicant, what?
had previously, both in 2017 and 2019, applied for permits, which part of the process is to apply first for a zoning review. So they were familiar with the process. Any updates that they had done, any major changes that were done to the plans after that through the portal. Portal is not shared between the Division of Zoning or the Office of Construction Code. The applicant was familiar to this point that these are separate processes, that one has to go through both processes to get a permit, to get updates. I just want to make that clear that portal is not the same as obtaining a zoning approval for any proposed work.
Right, so understood. Again, the zoning permits that were applied for were the initial application when he sought to undertake any work. And then the second one in 2019, which was also approved for when he sought to expand the property. Typically after that, and you can correct me if I'm wrong, I mean, I'm a homeowner myself. At that point, when you seek to make interior changes, to that nature, you would apply to update your permit, but not necessarily every single hot water heater change or this or that. Would you then go back and apply for another zoning permit? It's when you apply for the use and when you apply to expand the structure, that's when he went in and received zoning approvals. After that point, it was field changes that simply went through the portal system as typically as would occur. It would not be, correct me if I'm wrong, but I believe under the law, if the building department had any concerns about any zoning issues at that point, it's their job to actually send that over to your office and say, hey, we've got a concern. We don't think, X complies with zoning, or we'd like you to review it. Please do so. That's, at that point, because at that point, it's every single change that's going to be made is not going to be another zoning application. It just isn't. Nothing would get done, and practically, I just don't think that's how it works.
I will correct you on that. Any changes that do take place, the applicant is responsible to check with zoning to ensure that those changes are per zoning. And in this specific case, again, we don't want to go to the details because I'm not sure if you're appealing the details of the zoning determination or not. The applicant included a pool in their cellar. This is not a small thing that you do and you do not get permits for. And you do not extend your structure into the required setbacks by a certain amount without zoning approval. Again, this being part of the applicant's responsibility to come to zoning prior to receiving any type of building permits. I just want to make sure that it's on the applicant to ensure that they're following zoning.
Yes, and you're right. And those changes, which you've categorized as major changes, were on the applications that went in 2019. They were on the plans. They're on stamped plans by the building department as well. They're on the plans. I don't know what else to say other than they're on the plans. And if there was a mistake that, again, we can get into the specifics. I'm not sure why a pool wouldn't be permitted within the structure, but even setting that aside, they're on the plans. We have stamped plans that show a pool. We have stamped plans that show the structure and its location. I don't know what else to say other than we have a 2019 zoning approval as well. And the issue obviously came up at some point between 2019 and 2021, but all of the construction that was taking place at that time is under permit. That's really all I can say. Again, we can go through the specifics after as to the merits of whether or not a pool is a zoning issue or not. Again, I don't want to touch on that now because I don't want to start going back and forth on interpretations when I think my case is on a facial level. We have the permits, unless we've so to speak proven our case in the fact that we have stamped plans and we filed an Oprah request for asking the clerk, the building department, the zoning department, is there anything else that we don't have that they might have that would prove otherwise? And we've not gotten that. And we've got Oprah responses saying, oh, here's a plumbing permit. Really not kind of outside the scope of the zoning issue we're talking. But my point being, you're right, it is our burden of proof. But I would stipulate and put forward that we meet that burden of proof by showing that we have the permits in place and a right to rely on those permits.
which I mean, we're going back and forth, which did not have zoning approval, but go ahead.
Okay, so Miriam, is there anything else that you want to add?
No, it's the matter of fact of that the work was, the great extent of work was done without zoning approval, and unfortunately, it's not in conformance with the chapter 345.
Okay. Staff, is there anything else that we should be considering other that hasn't already been said? And I know that we'll open this up to the public.
No, I mean, so I did send out my staff report. I think it's pretty comprehensive with the timeline and with all the relevant citations. I can go through that, but it doesn't, it might seem like seems like a little bit overkill since
I mean, can I ask you a silly question, Tanya? Is this as simple as, did they submit a permit with that had renderings of a pool and some other things? Was that approved? Did they go off of that? Or should that not have been considered a basis for some of the construction that they did?
I mean, Miriam might actually be able to answer that a little bit better, but my understanding is that there was the original zoning approval in 2017. And then in 2019, they went to actually go ahead and start construction and do underpinnings. And my reading of that approval letter is that it's, you know, there's a lot of reference in there to previous approvals. Where I'm lost is that I didn't see any plans. I think there's a copy of plans, photocopies of some of the sheets of the pages from the plans that were from 2017. I don't know if that was also submitted again in 2019. The building department didn't have any plans for me to review. So that is the question, but
okay.
I don't know if that answers your question or not, but
I don't know. And then I don't know, Miriam, if you can answer it, because I guess I don't know the answer. It's like, you know, obviously, if I try to build a house and I get approval to build a house to certain specs, I can do it under those parameters. That's not a blanket that, you know, if it's approved for me to build like a 2-story house and I build a 3-story house,
that is
well,
correct.
I've done more work than I've been permitted to build. And I don't know how to answer this question.
And again,
Yeah, Mr. Chair, I would just throw in there, you're spot on. But if in the course of construction, you decided, oh, you know what I'd really love is a 3rd story on my house, I'm gonna update my permits and put that in. And it's shown on the plans and you get the permit for that in good faith, not thinking and this is where the law kind of gets a little bit more detailed, but it says if you knew going in, for example, if you applied for a permit to put 16 extra stories on your property, knowing this is an R1 zone and that is beyond the pale of anybody's logic, and for some reason the building department issues in error a permit to do that, there is case law that says you do not have the right to rely on that permit. But if you file to put a 3rd story on, knowing that you're permitted 3rd stories, you file to have a pool in, seeing nowhere in the zoning ordinance that there's an issue with having a pool in your house, and the building department approves that, you do have legally, and I'll defer to counsel as well, but you do have legally a right to rely on that.
Okay. I don't know if any of you have anything to add. I don't know what else I can
I would say I
determine.
would agree with Mr. Wine. At some point in time, you do have a right to reasonably rely on something you're given. I understand what Marion is saying, you know, but she's actually saying sometimes the left hand doesn't know what the right is doing.
And that's not that doesn't matter.
Yeah.
I think that's a faulty way of thinking about this. I think the city's stronger argument is that you get X and you can't do too much more than X.
Right.
And this is where I get back to, like, this has to go to a court. There's too much here for us to think about, so I'll vote anyway to get this to a court. Here's what I think, and I don't know what other commissioners think. There's something going on here. Something is suspicious. I don't know if it's the applicant or something from the city or a city actor who's interested in what's going on here. It needs to be investigated more. I think that there seems to be a rational basis for why the city ruled the way they did. I am going to vote to deny the appeal, which simply gives Ben an opportunity to keep this going with the court,
So, Mr. Chair,
which
and
he's doing anyway with the first part.
And I appreciate what you're trying to do. I totally get that. And it's, I'm not going to say you feel unqualified and that this is an issue of fact, but under the law, if we file an OPRA request, have that, review that with the city, so to speak, review the facts on the record, and there's no dispute to the facts, then I'm not sure that it's honestly quite fair to the applicant to now continue leaving a site that he can't get a CO for, because it's going to take months and months and months, if not more than that, to get to a court, simply where the court will say, okay, what discovery do you have? And we'll say it's exactly what has been submitted to the board. I mean, it's
Okay.
so I appreciate, so I kind of just want to put that.
But to be fair to the applicant, wouldn't it be better to do the reverse? To uphold the appeal, and then let the city then decide in the municipal level that we were wrong or something, and take it that way. Why are we putting the burden on him? You know, if he's doing something within the four walls of his house, like putting a pool in the basement, which I guess seems a little excessive. I don't have a pool in my basement. Then again, to put a pool in the basement, you need a plumbing permit, you need an electric permit, you need all these permits. Somebody's coming in to inspect. I mean, you would think an inspector would scratch his head saying, whoa, how many pools in the basement are there in Jersey City? There can't be that many in a 1 and 2 family home. Maybe he would have said at some stage, you know what, this doesn't look right. Did you get zoning approval? Maybe we should hold off on this. But it doesn't. We're at the very end when he's going to get a CO, and now all of a sudden you say, well, hey, listen, you shouldn't have put the pool there. It's a little late in the game. There's a lot of steps to putting a pool in your basement.
And Mr. LaPaglia, I appreciate that. And that's kind of the point that I'm making. Again, not to get into specifics unless the board decides they'd like to, but for example, there's nowhere in the zoning ordinance, whether it's excessive or not. I mean, that's a property owner's choice. People do crazy things, but there's nowhere in the zoning ordinance that says you can't have a pool there. It says in the zoning ordinance, you can't have a pool in your front yard, but it doesn't say you can't have one inside. And I would challenge zoning to confirm that nobody in the entire city of Jersey City has a pool inside their house. I just think that, so I don't want, I'll get into the specifics on the appeal if you like, but that's the as applied. I'm focusing right now on the facial. We got the permits that we needed. This was an open process for almost 6 years. And to delay this further when at no point other than at the end of construction was an issue raised about, oh, maybe you should have needed approval for that and shouldn't have gotten the permits. Frankly, at that point, it's just, I hate to say it, but the case law, which I'll give the citation if you like, is pretty clear that as long as it was reasonably applied for and in good faith, there is a right to rely on those permits.
So is there a question of fact? Because there's like, what is the basis here then? Maybe I'm just really misunderstanding between what the zoning officer's saying and kind of what the appellant is saying here. Like, what is the misunderstanding? Isn't that an issue of fact? Vinny, am I misunderstanding this?
No, when you're looking at July 2019, the building permits reference the pool, where actually everybody across the board is correct, is that somebody in construction code should have flagged it. Yeah, I mean, that is indisputable. The process is also kind of indisputable, right? Like even in the zoning code, it explains that you have to go through zoning before you do any work, to what extent. So those two things are true.
Okay, then I guess, okay, Vinny, you convinced me. I mean, if the process is outlined the way it is, the city feels that something was done that was improper, let the city keep this going. And I guess if we vote to uphold the appeal, the burden's on the city to keep it going, right?
Yeah.
I think.
Okay. I like spoke a lot and didn't let other commissioners speak. So does anyone else want to say anything?
I'm a little maybe not understanding Mr. Wine. Do you have the permits that you're speaking of? I mean, that with the approvals.
Yes, I do. And like I said, I thought that package, Miss Marion, correct me if I'm wrong, did your report, it was posted on the portal, right? I think it was. I have them. I can share my screen if you like. You know, it's 107 pages I'm seeing. So we could walk through each of those pages. I think better than that, we could also go through, if you see Miss Marion's report, her pages 5 and 6 detail and outline what lines up with her attachment. And that is the timeline of events. There's 3 arrows that you would see. So that might be kind of a more efficient way to look at it. But
Well, I'm looking at what she had up. I think that's it. Yeah.
Yeah.
Okay.
Yeah. And again, if you want to walk through those, we can, but that I would stipulate, I agree with that timeline that Miss Marion came up with as well. I think that is accurate. That accurately portrays what the documents that have been received from the Oprah request portray.
So,
the engineer letter requested as work was done without permits. Am I reading that correctly on November 2019?
Correct. So in November
Updated building permits?
Correct. So what happened in November 2019 is regarding underpinnings that were not done with the appropriate permits. So the city, actually, that's when it was either the plumbing inspector or the building inspector requested engineer verification, which was provided, and it's in the package, that says that it was built to code. And then they signed off and said, okay, as long as your engineer will verify that, that's fine. That was kind of a one-off update to the underpinnings that were already approved and began almost a year earlier in February of 2019. So yes,
what the statement says, engineer letter requested as work was done without permits.
Correct, regarding the underpinnings at the time, correct. But if you look back to the arrow above, February 14th of that year, building approvals for basement underpinnings and exterior stairs. And then if you look actually to July, so 4 months after that, permit applied for issue control for addition and alteration, contract shows pool, and denial issued for pool venting. So there was an issue with the pool venting. You fast forward to September of that year, permit issued for conversion from single family to a 2-family, adding a deck and a kitchen. And then to your point, Commissioner, in November, I don't know, I don't read plumbing subcode text, but there was an issue that perhaps maybe Miss Marion is more versed in that, but there was an issue obviously regarding some change to the underpinnings that was not done with a filed permit. So they requested that an engineer letter be provided, which was provided by an engineer, and I have that as well, that it was that it's quote unquote to code. And it seems that was accepted, you know, because there were final inspections passed from all subcode officials at this point, plumbing, electric, fire, building. So there was a blip. I can't speak to, you know, whether that was just a contractor. You see the next entry a year later, there was a change of contractor. I don't know if it was determined the contractor who did those initial revisions to the underpinnings did something incorrect, and therefore the engineer had to verify that. Look, I'm quite honestly, I'm not sure. But what I am sure about is that at the end of the day, every single subcode official throughout this entire process has said this complies until its completion in 2021.
Wine, I have a question. So you've said that you agree with the timeline. Is that correct?
I would say that from my review, it seems to accurately, and again, I only got this yesterday. But it does seem to comply and with what I've determined through my due diligence. Yes.
So does that mean that you acknowledge the fact that there were denials that were given?
Yes, in 2021, after the work was completed.
Starting in July of 2019.
in July of 2019, there was a plumbing subcode denial, not a zoning denial, a plumbing denial for pool ventilation, which was corrected. Again, these are, I don't mean to be coy, but Commissioner, throughout the construction project process, anybody who's been through it will know that there will be things that pass inspections, there will be things that pass permits, there will be things that don't, there will be corrections that have to be issued. I read that, and Ms. Marione can correct me if I'm wrong, as we don't like the plumbing subcode official saying there's something wrong with your venting, fix it. This doesn't pass inspection. And then it was subsequently fixed.
Where did the denials get sent to, Mr. Wine? Do you know?
Everything is done through the portal with respect to construction permits. It's
No,
all,
not the permits, but zoning denial, like the communication of zoning denial. Where does that go? And I apologize if I should be better schooled on that. But who gets that communication?
that would be, presumably that should be the property owner. So he got that again in 2021, between January and February 2021. It's actually the same thing. The January 21 is a recommendation from Raquel, who I guess was somebody who was with zoning at the time or might still be there, to issue a formal denial. So 15 days later, February 5th is when that denial was issued. Yeah, I mean, that went to the property owner. I think I acknowledge that we got that. It's just that after the construction was completed.
So I would like to add to this, when an applicant applies for zoning plan review, it does not mean that the project is done. It means that they're proposing work to do. So there's a distinction there. You continuously saying that the project was done. When you apply for a zoning plan review, you're saying that you're proposing certain work. It does not mean that you have finished work. That will be the process where it's become certificate of occupancy process.
Right.
So
But
your applicant twice applied for proposed work on actual architectural plans saying this is the work that they want to do. And again, once the zoning officer reviewed it, saw a pool and other issues, and subsequently it was denied twice.
so with respect, and I don't totally respectfully, if you look at that request in 2021, it's actually simply says request to convert from 1 to 2 family. That's all that it says. It's not request to add to the building. That was all done already under permit. It was a request, and I can bring that up, but it was a
You should
request.
discuss that also with your with the applicant. However, there is a different process to change use if it's occupancy, subject to occupancy, and there's no work being done. The process to file plans is to say that you're proposing certain amount of work to be done on the property. It's not simply saying that this is what I have done and it's that.
Again, there was no point where it was, this is what I have done. It was at the conclusion of the large conclusion of the project in 2021. It was an application to zoning to say, you know what, we'd like to make this a 2-family, which is permitted in the R1 instead of a 1-family, apply to zoning. And that's when the denial came in. So it was not an application to do any more work. It was an application for the use, which I agree with you, should have gone to zoning and did go to zoning. And again, I can get into the specifics. I don't know why zoning denied a 2-family in the R1 zone. I'm miffed by, but even aside from that, that's what that denial is based on. Not I'm applying to do work, I get a denial and I'm going to go about and do it anyway. It's I'm applying to now take this structure that has been completed under all of the permits we've talked about. And now I want to say, you know what, better than a 1-family, I'd like to apply to zoning to make this a 2-family.
To make it 2-family, you have to propose work. You can't just simply say you're going to make it into a 2-family. That means you have to put a kitchen, you have to put additional, there's work to be performed. It's not so, and for those, not specifically for putting a kitchen, but for the proposed work within that, within those plans, the applicant got denied. Also, I would like to add the zoning officer realized that the plans are quite different from what was approved originally. And mind you, it was not in conformance with chapter 345.
Again, I'm trying to, I think we're all at the same page here as to what happened, whether it should have happened or not have happened, and all those iterations of plan submissions through the portal. at some point should the building department have said, yeah, you know what, this gives me cause for concern. But I can tell you that in 2019, what zoning saw had a pool. In 2019, what zoning saw had.
That's actually incorrect. I want to correct that. The plan that you're referring to does not, and the plan that you're referring to with the pool, per our records, per zoning officer does not have signature and approval of the zoning officer, the one with the pool.
All I have is the zoning approval from that time period that matches those plans that says approved.
Unfortunately, neither the applicant or anybody has been able to provide us with any type of approval from the zoning officer that indeed there was a pool approved in the structure.
So again, with respect, I have the date of the plans that were submitted and I have the date of the zoning approval, and I have Oprah requesting the actual plans with the zoning officer's signature on them, to which the response we got is we don't have that.
They don't exist. That's the reason.
I don't know what to say beyond throughout this process, it continued to go through the channels. We got the permits. We have the right to rely on those permits. That's if you want to walk through the specific, at the risk of just keeping the board, totally consumed by, unfortunately, what I acknowledge is a circular situation. I fully acknowledge that. But I'm happy to walk through the specifics as well. And if you can, I'll defer to I see you unmuted, Mr. Chair. I don't, it's 9:21. You have other applications. I'm not looking to,
Yes, I agree. Look, this board right now in this hearing, we're not gonna go through, you're not submitting, some discovery motion,
right,
that'll have a million, exhibits that we're gonna consider various factors for. So yeah, Sonia.
I'm still back to my same point, Mr. Chairman.
I agree with you, Vinny.
Somehow the building department made a mistake somewhere. It's not up to the applicant the applicant can rely on these permits. And that's what he did. So yeah. I think the ball should be on the other foot. I mean, uphold the appeal. And if the city doesn't like it, the city takes it to a different court, and then we have all sorts of discovery. But right now,
yeah,
we have permits, we have approvals, and it's at the end of the day, when you go get a CO, somebody says, you know what? You didn't get a zoning write-off on something you did 2 years ago.
Vinny, I completely agree with you. I want to not hear anymore. Did we open this up to the public yet?
No, I think we should.
Okay. Anyone from the public have any questions or comments, specifically only to this application, which is 4 Highview Road?
I do see 2 hands raised. Oh, 3. Promoting Melanie. There we go. Melanie, if you can unmute and
okay, can you hear me?
We can hear you, but we can't see you.
Oh, I'm not sure how to do that. Let's see.
Right next to the mute.
There we go.
There we go.
Here I am.
Okay, would you raise your right hand to be sworn, please?
Sure.
Do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And could you state and spell your full name for the address?
Melanie, Melanie, Merriman, Merriman. And I live at 112 McAdoo.
Thank you. And I assume that's in Jersey City, right?
Yes, it's a block away from Highview Road.
Okay. Okay. You have 3 minutes, whatever is
Okay,
on
I
your
just have
mind.
a question. I don't see in the plans anywhere where they put in, they put in a third story on this house. Okay? It's the only third story in this whole neighborhood on Highview Road, which is totally out of character. It shouldn't have been allowed. And it's not a two-family house, it's a party house. He has parties in it every weekend, loud parties. He says it's an Airbnb and it's a bed and breakfast. It's not. It advertises on a website. It's a party house where you can rent it on weekends. This is not fair to this neighborhood. It doesn't belong in this neighborhood. Cars go, I don't know if you know, you should Google it. Google the house and you'll see this obnoxious thing that they built. It's totally, and who puts a pool in a basement if it's not going to be a party house? I just find this very disturbing, and all the neighbors around here are very, very upset. And we don't know what to do, so we're turning to you. We all tried to come here to turn to you for help. I don't know what else to say because I'm very upset with this Highview Road business.
Melanie, I don't know if
Thank
you'd
you.
like me to respond, and I'm sorry that I missed your last name, or I.
Merriman, Merriman.
So, Miss Merriman, I'm happy to respond to that. As I said at the beginning, I am just as disturbed as you if there was an issue about using the site in a way that it should not have been used. It's why I withdrew that element of the appeal. If
No, I
there,
understand that.
and to that point, I'm not disputing that with you. And I told my client, look, I'm an attorney. I can't, I'm not an enforcement official. I told my client, any operation of an event space, a bed and breakfast, a 5-family house, a 7-Eleven, anything that's not a 1 or 2 family house, with certain other exceptions, is not permitted in the R1 zone. If you're going to engage in that activity, or if you have engaged in that activity and received a violation, I'm not representing you appealing that. If it's a violation that goes to court, fight it out and either plead guilty or not guilty to it. And going forward, all I can do as an attorney is advise you to that. So I agree with everything you're saying, Ms. Merriman, regarding the use. That's not what I withdrew that element of the appeal on behalf of my client because he appealed everything that was available that he did before he hired an attorney. I told him I'm not prosecuting that appeal. It's not, in my opinion, it's not a valid appeal. I think you're 100% spot on. As to the third story, though, 3 stories are permitted in the R1 zone. But even besides that, again, it was submitted under permit and approved, but it's 3 stories, whether it's in context with the neighborhood or not. Correct me if I'm wrong, probably Ms. Yagubi or Ms. Marione, but you are permitted 3 stories in the zone. And again, it's not a variance application in that realm. And I don't mean to be dismissive. I want you to feel that I addressed your comments within the scope of the hearing that we're here discussing and the matter that we're here discussing, which is whether permits were received and whether we have a right to rely on those.
Mm-hmm.
Well, then
Thank you.
Promoting Julie. Julie, if you can unmute yourself and turn on your camera, please.
Camera.
Let me ask you.
Yeah, I unmute myself.
No, not yet. Do you have your video?
Yeah, let me see. Give me 1 second. Let me try to do it. Yeah.
It's right next to the.
Okay. Yeah.
It's a close out.
Okay. How do you do that?
Ms. Nguyen, while you're trying to find this video feature, I would just say the same thing that was commented to the first person from the public, that we're not talking about the use. of the space. The appeal is only about the reliance on permits.
Francisco, is it possible to promote somebody else while Ms. Nugent, however you pronounce her name? is
There
trying
was
to-
a hand raised, but after Chairman Jacobs' comment, the hand went down. So this is, and that person left.
And
There's
so did
the person who was in the panel
Julie.
list.
Okay.
Okay. So
Oh, I do. No, Melanie already spoke. Unfortunately, we cannot promote you for a second time. Correct me if I'm wrong, everyone, but
that's correct.
Correct.
All right. Well, I don't know what this person's going to say, but why don't we give them 5 seconds and then we can close the public? Okay, so we're closing the public. Staff, do you have anything that you haven't already said on this? And the answer could be no, we're ready to make a motion.
I don't have any further comment. I think I made it clear what the zoning division position is.
Okay, any other staff members?
Nope, like I said, I have the timeline that's provided, and I think Mr. Wine and Mr. Gobi went through it pretty exhaustively, so.
Okay. Anyone from the board want to hear any more back and forth dispute of fact?
I'm good.
Does anyone want to make a motion? Okay, either way, someone can make a motion to uphold the appeal or to deny the appeal. And it doesn't even need to be what you believe.
Mr. Jacob, I'm sorry, Mr. Chair, would you, I know the answer is going to be no, but if you'd like, would you like me to sum up at all to
I'll hold
reframe
my
the legal
tongue.
issue?
I really don't want any more, but maybe other people want to
Oh,
hear
good, good.
more from me.
I think we're just so confused. We don't know how to approach.
All right,
the-
Vinny, do you want
voting.
to articulate where we need to vote?
Mhm.
Vinny, are you
You're
able to
with-
summarize the
It's-
position, please?
It's simple enough. If we're going to say that Mr. Wine has the, and his client have the right to rely on these permits, and then we're simply going to say at this stage, we'll make a motion to uphold the appeal.
Oh,
It's,
Yep, that's it.
yeah, make it
Okay.
as simple as possible.
okay, we can do that. All right, I make a motion. Z 22-085 for Highview Road. I make a motion to uphold the appeal. I think Mr. Wine made his case.
Kim, did you just second that? You're on mute.
Yeah, I'm sorry. Second.
On a motion to uphold the appeal reversing the zoning officer's violation. Commissioner Shadid,
Yes.
Commissioner Green,
Yes.
Commissioner Park,
No.
Commissioner Donnelly,
No.
Commissioner Arujo,
Yes.
and Chairman Jacobs.
Yes.
Motion carries 4 in favor, 2 oppose.
Thank you very much, everyone, and I appreciate the time. I will not keep you any longer. I'll see you in a couple of weeks.
Thank you.
Okay.
Thanks so
you.
much.
All right, bye.
Okay, so now we're proceeding with case Z22-061. The address is 74 Graham Street.
What are we
Chairman,
doing?
this is the last one.
This is the last one. And then we're
Okay.
going to stay on the record, and I'm going to talk about how Mr. Hudnut is going to take these back over, and he's going to appear on our at all of these meetings that this is going to happen going forward.
Yeah, this is exhausting. It's too much.
It's
a lot.
So do we call this case, Mr. Chairman? I didn't,
I thought I did. I can call it again.
I might as
Good evening, Joseph Elmocauda of Schuman Hanlon Margulies on behalf of Moizuddin Mohammed. This is 74 Graham Street.
Mr. Cowder, we did review your notices, affidavit and proof of service, your notice of publication. Bridget, we're going to mark that as A1 for this application.
Okay, one moment. Okay, A1 in evidence.
Not to short circuit things, but it's looking at this appeal, didn't we? I mean, we heard something similar. So are we going back to the 2007 photograph to see if there was something different?
This project is a little bit different because the landscaping and the parking was created between the year of 2021 and 2022.
Oh, okay, so there goes that.
Yeah.
Well, there's a little bit of nuance to this one.
Go ahead.
I guess first as a matter, I do have my client, I believe he's in the audience. We should say Moiz Mohammed. And I also have here a Carolyn Worstel of Dresden Robin to provide planning testimony in the event the appeal itself is unsuccessful, and she could provide testimony in favor of the variances requested.
Mr. Joseph, the applicant's name is it M-O?
OIZ.
Okay, I only see the first name, so I will promote.
Okay, probably MOIZ.
Yeah, I'm gonna promote them now.
Yes.
Thank you.
Well, I'm glad that you guys have counsel for this one because I only see one Google Maps image here. So the fact that I don't see historical images going back to 2007, that alone justifies the need for counsel on this appeal.
Yes, because looking actually at that image, the house is actually blurred out. I don't know if Mr. Chairman can see that on Google Maps or Google
Yes.
Streets.
Yes.
Oh my God, we're going back to Google Maps.
I do have photos in my staff memo if the board would like to see it, or if you want to.
Yes, please.
If you could put it up, and we have our own photos too that we'd like to enter into evidence.
Did we mark the notices?
Yes, we did.
Oh, okay.
Yeah.
Okay. Sorry if I'm scrolling fast. So these are some of the front photos as it is today, or as of January 10th of 2023. And these are some aerial photos of the property in 2014, 2021, and you can see in 2022. Let me know if you want me to zoom in into any or stop sharing my screen.
Zoom into 2014, please. Okay. Is that that big? Is that landscaping on the front here?
Yes,
Is
that's
that
correct.
supposed to be landscaping? Okay. All right. Thank you.
It's somewhat debatable, but
Yeah.
this this is not exactly what we hinged the case on here. And I will have Mr. Mohammed provide some testimony, or if you let me share, I'll show what brings us here today.
Let me know if you have access to it. I just provided everyone with.
Sure. One sec.
I mean, I really do hope that I'm going to start seeing attorney advertisements after today. You know, it'll talk about different subject matter expertise, and one of them will be Google image interpretation.
Google image interpretation with a subspecialty on front yard parking.
No,
All right, so I'm gonna share the screen, and I would just ask Mr. Mohammed to explain what these are.
Did you want me to swear him in?
Oh, yes, please, please.
Where is he? I don't see him up on the screen now that it's sharing.
Moise, here, do I get out?
No, he's here, but he's off the screen now. Just unmute and say something so you can pop up there.
Okay.
Okay, good. Raise your right hand to be sworn. Do you swear, excuse me, do you swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. I do swear. Yes.
And state and spell your full name, please, for the record.
Yes, my name is Moizuddin Mohammed, and the address is 74 Graham Street, Jersey City, New Jersey.
Spell your name, please.
Moizuddin, and the last name is Mohammed.
Okay.
Okay, we can go ahead. You can put your hand down. Moise, when you bought the property, you did some due diligence beforehand, correct?
Yes, Joe. Yes. So I mean, I searched for the property on the portal of the Jersey City database, and I found that this property has a approved driveway in multiple locations, and even on the different portal, like where you search for the property, and then it just shows up that the property has an approved carport since 1997, I believe. Yes, 1997, and yeah. So and then I made an offer, and then I got this house. Yep, and then yeah. Yeah,
so just in front of us right now, can you explain what we're looking at?
Yeah, so this is the data from the Jersey City zoning database, where it has the list of all the inspected and approved driveways for the properties on the Graham Street, and if you the section you have highlighted, it has my address on it, like 74 Graham Street.
Okay. Now I'm going to switch the page. Now, is this another way to search on the website?
Yes. This is another way of searching for the driveways and the carports. Yeah.
Okay. And you made this screenshot?
Yes, I did that. Yeah.
Okay. And you created this?
Yes. So I took these screenshots after I got the violations, after I got the violations, I took these screenshots.
Right, okay. But you saw this before the violations and before you did anything to the property?
Yes, yep.
Okay. I just want to put that forth. And I mean, the point of this application really is, kind of goes back to the one before us. Moise did his due diligence, looked and saw that the property was approved for a driveway or for parking in the front, and he relied on that. Now, if you look at also just the street generally, you would see that it's completely common. I'm going to share another image. One sec. Okay. Do you Okay, is this, do you recognize this?
Yes, yes, that's my, yeah, that's my front of the
This
house.
is pretty much how it looks today.
Yes.
Okay.
Yes.
Now, let me switch it. And this is a picture of Graham Street, correct?
Yes, that's a Graham Street. This is like right to, I mean, these are from my next to the properties, you know, the house lines like next to my property. Yeah.
Okay.
Yep.
And same with this. Just
yes, yeah. This is like yeah. This is on the other side. You know,
looking
on
from the other direction.
Yes, but they're on the same street, Graham Street.
Okay, and you'd see there's. It looks like many of the houses have parking in the front, correct?
Yes. Yes.
Okay. And do you recognize this one?
Yes, this is the next door house. It's a brand new construction. The address is 76 Graham Street.
Okay. And this was recently built like this?
Yes, recently, just like a month back or so, it was finished. Like maybe 1.5 months back.
Okay. Yeah, I mean, this is fairly simple. I mean, there's no picture from 2007 to look at on Google Maps that seems to be the standard that the city holds. And
Can we rewind a minute?
Sure,
What-
sure.
What portal were you just showing us that says that there was a carport approved there?
There is actually I'll have the witness explain how he found it, because I've found it, but I probably can't find it as efficiently. I go on Google, go to the city website, and I somehow find it eventually. Moise, can you explain how you found that?
I forget how he found it. Marion, does this exist, this portal?
The Division of Zoning has a list of all the historic and current curb cut and driveway approvals, put in an Excel sheet, and it's put online. If you notice on top, it says the list does not contain all the list of complete and, all legal carports, but it is a list. That list is there.
Right, I
And-
thought we had a book like that from a case that we did many, many years ago, that this.
We
this
have compiled
list
it into an
is-
Excel sheet, correct? There is this historic, we have information on historic approval of any carports and driveways, as well as the ones that get approved on daily
So
basis.
this driveway is on that list?
It used to be, yes, correct. It used to be on that list. There was an approval for this address from prior to the regulation changed in the city. And the reason I'm gonna elaborate on this case a little bit more, and the reason they received a violation is if the pre-existing use was abandoned and had not the use was essentially abandoned and not used as a driveway, it's no longer permitted to be a driveway. And from our understanding of the application, it was only turned into a driveway between the year 2021 and 2022, whereas prior to that, there was no driveway. Or there might have been historical driveway and it was removed and replaced by a landscaping, meaning the use of a driveway was abandoned from 1994, the year prior to 2001, where the amendment and the new ordinance was passed, not permitting parking of car between the building line and the right of way.
Oh, okay, but when did Mr. Mose buy this property?
In here, go ahead.
Yeah, December. Sorry, it was in December of 2021.
December or the summer? I didn't understand.
No, December of 2020.
December.
Yes,
Okay.
December. Yeah.
So he buys it with the parking space there. Is that what we're telling us?
No, right?
No. No, the thing is, I mean, there was a new construction next door, right? So they were doing a lot of work, and there was so they had these guys working, like putting the concrete and all. They had contractors coming in. So I asked them, like, hey, you know what, I have this approved thing, you know, like how do we, because the count, because I had no idea about the permits and all, but I did research on the permits, like what to take, what not, what permits I should get. So based on my research, I found out that I need to apply for the permit for the curb cut. So not for putting the concrete, you know. So I mean, when I talked to the contractor, they said the same thing. Hey, you don't need permit to put the concrete. You just need the permit to cut the curb. That I was planning to take the permit once the next house completely is done, because their trucks were, because this street is a narrow street and their trucks were parking on the sideways to unload the materials, and it was so heavy traffic. They already they did so much damage to the sidewalk, almost like 3 houses sidewalks, right? They have cracks in them because all the heavy trucks would stop on the sidewalks and then unload the materials. So I was like, there is no point of getting the permit right now and like doing the curb cut, because anyway, these guys are going to damage it. I was like, okay, waiting to apply for the permit once the house is done. But before that, I got the violation.
I would like to add that there were no permits filed for this work. That
Yes,
was-
There was,
yeah.
okay, that was what the testimony was, but as also though, the house is still on the approved list as of, I can put it back up, I believe it was August of 2022. So I mean, he had no reason to believe there's any abandonment or any knowledge of whatever the history was of the property before that.
They would have had to apply for a permit to be able to do the work, regardless of whether or not that was on the list. Additionally, mind you, the use was abandoned and they should have seek guidance from zoning.
But I guess what we're asking you, Marianne, in a different way is this. Let's assume he applied for a permit. I guess you wouldn't, this is like a speculation. Would somebody have looked and said, well, wait a minute, this, well, you're on the list, but it's abandoned.
Correct. Every time an applicant, this is the part of the process that we do at Division of Zoning, every time an applicant applies for any type of driveway, carport, any type of driveway related inquiry, we do the research and make sure that it's permitted, whether it's going to the site, pictures, Google pictures, what have you. It has to be done before any work is taking place.
Right, but all I'm asking you is this, what's making you think it was abandoned is that he's asking for a curb cut. Is that what you're telling us?
What's being abandoned is the curb cut was never there. There's no record of a curb cut being actually built there after 2001. The use that was essentially permitted prior to 2001 was never used, or if it was used, now it is abandoned because there's no carport permitted. There's no carport in front of the house.
I see. So somebody applied for a parking and
correct,
and never did it.
Correct. Yes.
Okay. And we wouldn't have known that until somebody comes in and asks for a permit to make a curb cut.
Correct.
If he came in and asked for a permit to just do over the cement, we wouldn't have known this, I guess.
Right.
And which, if we want, we can go through the pictures, you can see that half the street doesn't have curb cuts. They just drive up there because it's one of those streets where the road is almost as high as the curb, and you, for all practical purposes, you don't need a curb cut. It's less than a pothole. So,
okay.
I don't know. You get philosophical as to what is a curb cut.
Too late for philosophy.
Yeah.
I mean, too late at night, not to,
Yeah.
too late at this, but go, I'm sorry, I interrupted everybody. Go ahead. Where do we stand now?
I don't know, Vinny. I don't know if the applicant has more that they're trying to put together. Look, there's violation. What the way I see this, and I agree, Vinny, I'd like to short circuit this as much as possible. So I think since you guys did make variances or seek variances, we're gonna deny the appeal, and then we're gonna look at the variances and think about, well, based on what we think is appropriate for the space, are we okay with this use? Am I wrong in my thinking? Is that an oversimplification of the situation?
I think that makes sense. Especially since I have a better understanding of the building permitting process and that they actually never had the driveway in place until just recently. So, yeah. Great.
Okay.
We'd be prepared to proceed as such. I'm sorry.
So do we, do we need to hear from the public and then somebody can make a motion on this?
Yes. Is there anyone here from the public? This is only 74 Graham Street.
Chairman Jacobs, I do not see any hands raised at this time. Oh, spoke too soon. There are 2 hands that were raised. I am promoting Barbara Payne.
Now, we're just asking for comment on the appeal, not
Yep.
on the. Mhm.
Oh, that's weird. It seems like she joined the attendees list again. Promoting one more time. There we go.
Are you there, Miss Payne? No, you've muted yourself.
Looks like she unmuted herself.
Miss Payne, we see your name on the screen, but we can't hear you and we don't see you. So can you speak so we know that you're there?
Don't have to
Oh,
do.
We can hear you. But it seems like there's a connectivity issue.
Can you hear me?
Yes, now we can hear you.
Hello?
perhaps she could dial in by phone if we give the number. That might just be easier. I don't know.
Hello?
Yeah. Do we have to, we do have to see the,
You don't. Okay.
Are we, what's going on?
Hello?
I can't see Miss Payne's name. Can anyone?
Yes.
I can see your name.
Okay, are we able to, Bridget, are we able to proceed with her without seeing her picture? What do we have to do?
I don't think we can hear her either.
You're right. You're right. I can't.
Yeah, she's trying to say something right now.
Yeah, we're getting every other syllable.
Yep.
Can't hear her.
Perhaps she can call back in, or
is there another hand?
There is another hand on the phone. Should I promote them? Oh, there's
Yes.
2 different hands. Okay. I'm going to be promoting the first number I see. Or allowing to talk. And then to unmute yourself, you just dial *6 and you should be able to speak.
That seems to be just as bad.
Hello?
We can hear you.
Okay, should I go ahead and speak?
Yes.
Okay, yeah, so my
Well,
name is,
no,
okay.
okay, could you spell your name? I have no video, so I won't be swearing you in, but go ahead.
Sure, my name is Ariel Guerrero.
Spell that.
Ariel, last name Guerrero.
Guerrer.
Ero, yes.
And the first name Krieg?
A is an alpha, R-I-E, echo, L, Larry.
Ariel.
Yes.
All right, do you verify that you are who you just stated you are and that you will consider your testimony tonight as if under oath?
Yes.
Okay, sir, go ahead.
Okay, yeah. Yeah, so I live on 70 Graham Street, live here for 18 years. I do support this variance. I mean, it's number one, it'll reduce like it'll allow more parking on the street. There's already like not enough spots available. And it'll reduce like 1 spot. Yep, that's pretty much it.
Okay, thank you. Mr. Chairman, I'm getting a little bit concerned about our court reporter. It's after 10 and she may not be able to continue this. If we're gonna go on to the variance, unless Ms. Payne wants to speak on the appeal, but we're
Yeah.
really, I have a feeling she's here to speak on the variance. And not, but Bridget,
Can I suggest, let's just vote on the appeal and then carry the rest of it and vote on the variance next time and hear the other and hear the experts and everything, because
yeah,
if I'm this punchy, I can't imagine being Bridget. So.
I'll do whatever. Yeah, I'll do whatever Bridget wants.
I like Kate's idea.
Yes.
Yeah. Okay, great. So we're only voting on the appeal.
Yeah. So
Okay.
that's very simple. I assume the board was leaning towards denying the appeal and hearing the variance. So anybody want to make a motion to just deny the appeal?
Close the public to the appeal part though first?
We did
Yep.
not.
All right, I'll close the public. Okay, closing the public portion of this application. on the appeal? Can someone please make a motion?
We still have Ms. Green on board. Okay.
Anyone, please. Motion to deny the appeal.
I will make a motion to deny the appeal by 74 Graham Street in its case Z 22-061.
Great.
Second.
Okay, and a motion to uphold the zoning officer's violation. Commissioner Shadid,
Yes.
Commissioner Green,
Yes.
Commissioner Park,
Yes.
Commissioner Donnelly,
Yes.
Commissioner Arujo,
Yes.
Chairman Jacobs.
Yes.
Motion carries, all in favor.
Great. Okay, Mr. Cowder, I'm sorry, but we're gonna carry this, all right, to the next date. Is that March 9th?
Yeah, thank you for your time. I understand it's late and we'll live to fight another day.
Yeah. We'll hear. Sorry, Miss Burstel, but we'll see you again on March 9th. Thank you.
Thank you.
Thank you.
Okay, so we only have 2 resolutions to memorialize, so let's get this out of the way.
Vinny, before you do the resolutions, I do see Barbara Payne is still there. So Barbara, if you can hear us, this will carry to March 9th at 6:30, so you can rejoin to make your public comment on this application. Just wanted to say that.
Good. Okay, so the first resolution to memorialize is Mr. and Mrs. Patel, which was 2 Troy Street. That was Z 21-022. That was an application for preliminary and final major site plan approval with variance relief. That motion was not approved. 2 in favor of approving that, 5 opposed it. Present that evening were Chairman Jacobs, Vice Chairwoman Coyle, Commissioner Arroyo, Park, and Green. Those 5 voted to, in essence, deny that application by denying the motion, opposing the motion. Commissioner Allen and Commissioner Shadid voted in favor of the motion. But as I said, that failed, 2 in favor, 5 opposed. The last resolution to memorialize was Z 22-038. The applicant was at 100 Webster Avenue. That was for a C and D variance. That was heard on January 26th. Present that evening were Chairman Jacobs, Commissioner Shadid, Allen, Silva, Green, Donnelly, and Arroyo, and that passed 7 in favor, none opposed. Those are the only 2 resolutions, so I'm assuming we should make a resolution to close the meeting. This way,
Yeah.
Bridget can go to sleep.
No, you have to vote on the memorial.
Yeah, we have to vote.
Oh, sorry.
No.
Memorializing that. Sorry, I'm rushing along. All in
Aye.
favor? Aye. Did we vote on the first one? I forgot that as well.
I don't know. Can we vote aye on all of them? Okay.
Yes, well,
Aye.
we're voting
Aye.
to memorialize both resolutions.
Great.
Aye on both.
Sorry. Okay.
So Vinny, is there anything else? Before we close, there's one other thing I wanted to add.
Sure.
I think we still have Mr. Mohammed on board. I see the Moise here. Is that him?
I think
That
that's
small
okay. I
part?
don't know that we're in executive session, are we?
No.
Okay. So the one thing I wanted to add is on the Jersey City Municipal Prosecutor's website, in the second paragraph, it reads, "The Jersey City Municipal Prosecutor's Office is one of the most unique local prosecutor's office in the state. In addition to its responsibilities in court, it also leads the Resident Response Center, a one-stop resident resource for problem solving, and the Office of Code Compliance, a 45-member team of property inspectors responsible for enforcing our local ordinances." The way I read this, I believe that it's pretty clear that the responsibility for enforcing local ordinances is with the municipal prosecutor. I would then use that to say that on behalf of the board, we will not hear appeals of the zoning officers' decisions going forward unless I hear public statements before this board by Municipal Prosecutor Hudnut explaining to us and convincing us that my interpretation of this is incorrect.
You mean violations?
Yeah. Sorry, violations.
Interpretations are different.
Yes, I apologize. So, I mean, Tanya, Vinny, I mean, you tell me if I'm incorrect. I know we've already had this discussion, but we had a meeting today. I don't think it went extremely successfully. And I still don't think that we're best placed for this. But more importantly, we don't say in our website that we're the one-stop shop to handle these things. We don't have a 45-person team that handles this.
But we are the board that handles appeals from a zoning officer's determination.
Okay. If you guys tell me that that there's nothing we can do, then I guess that's what you're telling me.
Well, I think for the moment, we could maybe close the meeting and maybe Tanya and Josh and myself, we could talk tomorrow and.
Sure.
Way to do this, if there is such a thing, but let Bridget go. So that
Yeah.
we can,
Yeah, I just wanted to raise that all to you all.
So can we close the meeting and then we'll,
Yeah.
anybody opposed to that?
Motion to close the meeting.
Second.
Great.
All in favor?
Aye.
Aye.
Okay, good night, Bridget.
Good night.
Good night.
Night.
Good night. Have a
Wait,
good dinner, everybody.
Francisco, is the recording stopped?